A matter for 2:30 for this reason. There is threat of disposition. At first, proceedings are initiated tomorrow. Yes. Nagesh.
My lord,
Yes.
in this case, my lord, this petition filed for appointment of arbitrator to adjudicate the matter between petitioner and respondent, my lord.
Yes.
My lord, the petitioner father has entered into a lease agreement with the respondent.
Where is the arbitration clause?
Pardon?
Where is the arbitration clause?
My lord, in page number 31, may kindly see, my lord. 31, in page number 31, para 23, my lord. Notwithstanding anything contained herein above, in the event of any dispute arising between the parties under this agreement of lease, at the first instance, the said dispute difference of opinion be resolved amicably, and if not, by way of arbitration.
2009.
Yes, my lord. My lord, lease is for 23 years, my lord. Since there is a class 21, condition number 21 reads that if he fails to pay the rent for 3 months, then it has to be terminated. Accordingly, we have issued a notice to respondent by terminating the said lease agreement, my lord. Now he has not returned the position of lease premises. For the said reason, the petitioner has issued a notice requesting him to appoint an arbitrator, but he has not given any reply to our notice, my lord. For the said reason, he has approached this honorable court. Much obliged.
Yes.
The agreement is at page, my lords. Page 16, my lords. The document number 1, the arbitration clause is at page 34, my lords. Arbitration and specific performance. Page 34, my lords. Any disputes between the parties arising out of this agreement will be referred to arbitration under the provisions of the Arbitration and Conciliation Act. My lords, and the petitioner has issued the notice, my lords, to the respondent, and that has been served. And I have sought for appointment of 2 of the district judges. I have proposed them to appoint the names, my lords, and they have given the names as Justice Padmaraj, my lords. There is a dispute with respect. They have agreed for the appointment of the arbitrator. But only thing is that, my lords, at page 99, my lords, of their reply, my lords, at para 4, my lords. Our claims instruct us to state that the statements made in para 3 of your notice that in view of the fact that the aforesaid document are honest in the eye of law, no right could be asserted by our client on the said documents, and that when our client started harassing your client based on the document, your client was constrained to initiate proceedings in AA, which is pending consideration before the Honorable City Civil Court, and that apart the agreement of sale aforesaid stipulates for arbitration between the parties in the event any disputes among them are all not true, and our client is trying to twist as the execution of the registered documents, and that your client has obtained an interim order by suppressing the facts and by playing fraud on the court, and the suggestion of retired district and session judge Sri KG Ramakrishna Bhatt or Sri V.V. Angri as sole arbitrator is not acceptable to our client. Our client hereby nominates Honorable Justice B. Padmaraj as sole arbitrator for adjudication of this.
It's not acceptable to you.
Whatever the court suggested. My lords, whatever
you could have agreed for that. Where was the need come before this court?
My lords, I have suggested 2 of the names, my lords. They are suggesting.
See, it is up to the parties to agree.
So I'm suggesting for the district judges, my lord, so that.
Issue notice to the respondent.
The agreement, my lord, is at page 18. Arbitration clause, my lord, clause number 18 at page 24, your lordship will find. Clause 18.
Partnership agreement.
Please. Clause 18. Lordship has. Any dispute that cannot be settled amicably by mediation will be. Lord, I've sent my notice, my lord, dated 11/7/2022. Lordship find that at page 67. Proposing that the dispute be referred to the arbitration center. It's 70, your lordship will find paragraph 12. Propose that the dispute be referred to the arbitration center. But sir, my lord, thereafter a reply is received. Page 72, reply is received. Not refusing to consent for arbitration. Therefore,
In paragraph number 2, they say that is it's already a subject matter of arbitration.
so grateful, we had initiated proceedings before the Delhi International Arbitration Center.
Ah.
But because, my lord, the jurisdiction here is in Bangalore, we had, for whatever reason, wrongly initiated there. We've now withdrawn that case. We've now withdrawn it, and my lord, we now come before your lordships because, my lord, the jurisdiction clause is Bangalore. So, lordships, please come back to page 24. Venue for arbitration is Bangalore. Why that we had gone to Delhi, my lord, wrongly.
Issue notice to the respondent.
Yes.
There have two agreements for assignment been executed, which is at page 31 and 48, my lord. In page number 42 is the arbitration clause, which says that any dispute touching or arising out of this agreement shall be in far as possible be settled amicably between the parties in dispute, failing with the amicable settlement. The same shall be referred to and finally resolved by arbitration. in
Agreement
Bangalore
for
and-
assignment,
Yes, my lord.
2001.
Yes, my lord.
Assignment of what?
Assignment of the apartments, my lord. There are two apartments, 122A and 122.
2001.
Yes, my lord. There's a dispute between the builder and the landlord. There is a case pending before the civil court, and due to which they have asked us to wait till the outcome of that. Subsequently, one of the other apartment owner has filed a specific performance suit and got. The lordship may kindly see annexure T, my lord, 170 to 171, which they have written a mail to us saying that go before the civil courts for. And subsequently, if you go, lordship may kindly see the annexure AA, my lord, They have admitted the appointment of arbitrator, my lord. They have asked us.
Earlier, what is the annexure V? Earlier also there was a CMP filed.
Yes, my lord. This is another apartment owner has filed a CMP petition and that has been allowed. I will just forward to this notice. Similar one, my lord.
Issue notice to this opponent.
Machu.
79 A being one. Many cases refer to the.
Why did you file the appeal then?
Not filed appeal.
Why?
Because he is not aware of the facts that's what they are. Notice is not issued in this case.
Same order. ಅಲ್ಲಿ ಕೇಳಿ ನೋಡಮ್ಮ 17 and AB.
Prepare for petitioner, please.
Yes.
Paper petitioner. For property is ancestral property, the petitioner made a representation before the Tahsildar by annexure 20 Millard, page number 20. The ancestral property, below is the entrance to the RTC Millard. The RR is the my father name is there Millard. RR number is annexure B. He made a representation Tahsildar using endorsement, stating that is you are not file application before it said time allowed. That has been challenged before the assistant commissioner. That is the entries, the directions to entries. The assistant commissioner, the order was passed. The civil dispute is towards the civil side. There is no dispute of that at all. Only sought for entries to the RTC Millard.
Earlier it is standing in the name of Rudregowda.
Rudregowda.
Who is he?
For our father-in-law.
Father-in-law.
Father-in-law. And under 19 Millard, the Land Revenue Act, that is sought for the penalty and tax, received the tax and entries made in Millard.
Where is the RTC?
RTC Millard, page number 18 Millard.
ಅದು ಹೊಸದು.
First,
ಹಳೇದು ಅವ್ರ ಹೆಸರಲ್ಲಿ ಇದ್ದಿದ್ದು.
ಅವ್ರ ಹೆಸರು RTC ಬಂದೇ ಇಲ್ಲ.
ಮತ್ತೆ
RR ಇದೆ. RR ಅಲ್ಲಿ ನನ್ನ ಹೆಸರು ಇದೆ. RR ಅಲ್ಲಿ ನನ್ನ ಹೆಸರು ಇದೆ.
ನಿಮ್ಮ ಹೆಸರ?
ಹೌದು, ರುದ್ರೇಗೌಡ ನಮ್ಮ ಅವನ ಹೆಸರು.
ಹೆಂಗ್ ಬಂತು ಅವ್ರ ಹೆಸರು?
Ancestral property is cultivated unauthorized occupation.
What have you produced, sir? You have produced nothing.
The annexure B is RR Millard.
Annexure
B, page number 30. Serial number 1282. Chennai Roda is son of Ere Roda. In ಎರಡು items. Tagge Roda is son of Chennai Roda. 282 and 84 Millard. Tagge Roda is my husband. Chennai Roda is my father-in-law's father. Is in terms Vamsharuksha is also furnished Millard annexure A. Ire Roda is first Millard, Ajja Millard. His son Rudre Roda. Seal number 5. Seal number 8 is a petitioner. 9 is Ashwatha, is son of the first petitioner. Honestly, madam, honestly, common entity. Rudre Roda is it. Assistant Commissioner passed then civil dispute, you file a civil suit on there. Now, contention against the government with Tahsildar is not a partition dispute. Family dispute, there is no family dispute.
Huh?
There is no family dispute.
ಫ್ಯಾಮಿಲಿ ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ ಅಂದ್ರೆ ಯಾರ ಹೆಸರು RTC ಇಲ್ಲ ಅಂತಂದ್ರೆ
Whatever, any family dispute is file a civil suit. Is the only against entries change.
How, on what strength are you claiming that your name will be entered in the land records?
RR ಇದೆ ಸ್ವಾಮಿ, RR ನನ್ನ ಹೆಸರು ಇದೆ.
ಕಂದಾಯ ಕಟ್ಟೋದು ಏನು ಇಲ್ವಾ?
ಅದಕ್ಕೆ 19
ಯಾರು ಏನ್ ಕಂದಾಯ ಕಟ್ಟೋದು ಬೇಡವಾ?
That is the illiterate matter.
ಏನ್ illiterate?
ಕಟ್ಟಕ್
It
ಆಗಿಲ್ಲ.
also shows that you are not in possession of the land.
ಕಟ್ಟಕ್ ಆಗಿಲ್ಲ ಅದರಿಂದ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ 19 ಮೇಲೆ.
But the order of the Atila, they are so that we cannot remove it because we have taken application under 19. ಯಾವ್ದು annexure F? ಮೂಲ ಕೈಬರಹ RTC ಅಂತೆ ಬೀಳು ಜಮೀನೇ ಆಗಿರುತ್ತದೆ. ಬೀಳು ಜಮೀನಿನ
I am sought for only RTC.
They are challenged. Page 31. Page 31 of the next page. Page 31. ಹೆಂಗ್ರಿ ಸಿವಿಲ್ ಸ್ವರೂಪ ಆಗುತ್ತೆ? ಯಾರ ಮುಂದೆ ಯಾರಿಗೆ ಹೂ ಇಸ್ ಡಿಸ್ಪ್ಯೂಟಿಂಗ್ ದ ಟೈಟಲ್? ಮತ್ತೆ ಇವರು ಕಂದಾಯ ಕಟ್ಟಿಲ್ಲ ಅಂತ ಪಡ ಅಂತ ಮಾಡಿ ಅದನ್ನ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ then the same orders whatever it is, but if they admit that their ancestors name was recorded in the record of rights, then how can they deny entry? ಅವರೇ ಬರೀತಾರಲ್ಲ. Who is this respondent number 4?
4 is my sister's son. Sister's son.
He is disputing, is it?
No, he is not a dispute.
Then why have you made him a party? ನೀವ್ ಯಾಕೆ ಪಾರ್ಟಿ ಮಾಡಿದೀರಾ ಅವ್ರನ್ನ?
ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅಷ್ಟೇ. ದಟ್ಸ್ ಆಲ್. ಓನ್ಲಿ
ಎಲ್ಲಿ ಪಾರ್ಟಿ ಮಾಡಿದ್ರು?
AC ಮುಂದೆ ಹಾಕಿದ್ದಾರೆ.
ನೀವೇ ಪಾರ್ಟಿ ಮಾಡಿದೀರ ಅವ್ರನ್ನ? ಏನಕ್ಕೆ ಮಾಡಿದ್ರಿ?
is a civil court party. ಅವ್ರು ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಗೊತ್ತಿಲ್ಲ ಏನು ಅಲಿಗೇಷನ್ ಇಲ್ಲ against them. There is no allegation.
ನಾವೇನ್ ಮಾಡೋದು ಸರ್? ನೀವು ಪಾರ್ಟಿ ಮಾಡಿದೀರ ಅವ್ರನ್ನ?
There is no allegation.
What can we do? We have to issue notice ಅಷ್ಟೇ. Learned AGA takes notice for response number 1 to 3. Issue notice to respond number 4. Learned counsel for the petitioner is direct to serve a copy of the petition on the learned AGA.
The petitioner's husband, the day I was granted the land in year 1956, in survey number 1 of block number 128 of Velli Betta Kaval, Carpete Talak. Similarly, the same survey number, Sannaya was also granted 4 acres. And behind back this Sannaya, made the Podi and Durasti, and new number was assigned as 260 to the Sannaya. And that order was challenged.
Sannaya.
Sannaya, one Sannaya. His his new survey number was assigned to his possession 260. This order was challenged. Namdu one grant ಆಗಿದ್ದು. There are 120
survey number
one. Both persons is survey number 1.
ಅಲ್ಲ ಆಮೇಲೆ ಹೊಸ ನಂಬರ್ ಏನು
ನಮಗೂ ಕೊಟ್ಟಿಲ್ಲ, ಅವರೊಬ್ಬರಿಗೆ ಕೊಟ್ಟಿದ್ದು. Only one person out of 128 persons. And there afterwards I have prepared the appeal before the ADLR. ADLR was dismissed.
ಏನಕ್ಕೆ?
The Durasti is incorrect. Durasti without taking all the persons and without measuring the properties of all the one survey number 1. Only to the extent of 4 acres Durasti is made is incorrect. That was rejected and appeal prepared. Appeal is also dismissed.
Who filed the suit?
Suit both of us filed. Both the Sannaya was also filed. Doddaya is also filed.
ಅವರೊಂದು ಇವರೊಂದು
For
declaration
and permanent injunction.
What happened to the suit?
That was dismissed because identification of the land is not possible. So there the 260 assignment was made, and thereafter finally I have approached this honorable court.
ಇಬ್ಬರದು ಡಿಸ್ಮಿಸ್ ಆಯ್ತಾ?
Iburdu dismiss. And finally I have approached this honorable court at annexure E, page 63, my lord. What this honorable court says, all set aside ಮಾಡಿ ಎಲ್ಲಾ survey number ದುರಸ್ತಿ ಮಾಡಿ ಅಂತ. 67 is the operative portion of the order. 63 page annexure E, operative portion is page 67. Last 4 lines. I direct the petitioners and that the 6th respondent to appear before the Assistant Director Land Records, Pandupura, on 1/2/97 without awaiting any notice, and extend their cooperation for the purpose of measurement and identification of the land are granted to them. But they have not done, my lord. Instead of they have gave the endorsement, and that endorsement is challenged before this honorable court in 2021 WP 16-948.
So you have taken your own sweet time.
My lord, one time, but they have
1997 is the order.
97 2016 ನಲ್ಲಿ they gave the endorsement.
ಅದನ್ನ ಹೇಳ್ತಾ ಇರೋದು. You are required to appear on a particular day.
I appear, they have not passed any order.
So ಮಾಡ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ you should have filed a contempt petition.
They have not taken any action.
That is why I said you next filed a writ petition only in the year 2021.
21 they gave the endorsement. This honorable court
ಏನಾಯ್ತು 2021 ಅಲ್ಲಿ
21 ನಲ್ಲಿ specific direction was given. At this stage, the AG, the perusal of the papers indicates that there is no particular notice which has been issued to the petitioner, nor any proceeding initiated. Apparently, the impugned para 4 minute. Impugned correspondence on 27/4/2016 have been necessitated on account of representation made by the Tahsildar to the Assistant Commissioner, which has been acted upon by the Assistant Commissioner. Such a procedure is unknown to law. Well, thereafter, para 6 at this stage, learned AGA submits that before carrying out Podi and Durasti work, it is required for the authorities concerned, more particularly respondent number 2, to come to a conclusion as regards the validity of otherwise of the grants made to various persons. There is merit in the submission made by the learned additional government advocate. Respondent number 2 shall issue notice to all the stakeholders, including the petitioner, arrive at a finding as regards the grant made, and thereafter communicate the said orders to the respondent number 3 within a period of 6 months from the date of receipt of this order. The Tahsildar, upon receipt of the copy of the said order, along with the respondent number additional director land grants, shall carry out the Podi and Durasti proceedings as per the order passed by the Assistant Commissioner within a period of 6 months. Thereafter, the issue notice to all the persons stated they have a right to the property to the Assistant Commissioner. Respondent will act on a printout of the uploaded copy of this order on the website of this court, if so furnished the petitioner without waiting the certified copy thereof. If the respondents have any doubt about the order, they may verify and the contents of the order from the website of the courts and from the learned AG. But now without issuing notice and they have passed the order at annexure.
ತಿಳುವಳಿಕೆ ನೋಟಿಸ್ ನೀವೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ?
ನಾವೇ ಕೊಟ್ಟಿದ್ವಿ, ಅಪಿಯರ್ ಆಗಿದ್ದೀವಿ. ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಫರ್ದರ್ ಡೇಟ್ ಇಲ್ಲ. I have produced the order sheet also.
The direction was issued to respond number 2, Assistant Commissioner.
Assistant Commissioner.
Respond number 2 shall issue notice to all stakeholders, including the petitioners, arrive at a finding as regards the grant made, and thereafter communicate the said order to respond number 3. So this is what the Assistant Commissioner has done now. You know, 37.
No notice is given to all stakeholders.
How can he delegate this exercise to the Tahsildar when the direction was issued to the Assistant Commissioner? He was directed to secure the records, look into it, pass order. How can he delegate this exercise to the Tahsildar? The document, yes, that was required to be summoned from the office of the Tahsildar. What are they doing? Please read the order passed by this court. Respond number 2, that is Assistant Commissioner. Correct. Yes. So therefore, the Assistant Commissioner was required to summon the original records, look into it, come to a conclusion as to whether a grant was made in their favor, and accordingly direct the Assistant Tahsildar. Now what has he done? He has directed the Tahsildar to verify whether there is original grant register. Then how could he close the matter then? ಅಲ್ಲ ಅದು ಉಳಿದ ಅವ್ರದಲ್ಲ. ಈ ಫಸ್ಟ್ ಪ್ಯಾರಾದಲ್ಲಿ ಏನಾಯ್ತು? ಆದೇಶ ಫಸ್ಟ್ ಪ್ಯಾರಾದಲ್ಲಿ ಏನಾಯ್ತು? This is the order pertaining to this writ petitioner. ಬರ್ಕೊಳ್ಳಿ. It is not that they don't understand the orders passed by this court. They deliberately do all these things. Learned AGA takes notice for all the respondents. Learned counsel for the petitioners is directed to serve a copy of the petition on the learned AGA. Next para. Earlier, the petitioner was before this court. Contempt petition file ಮಾಡಿದ್ರೆ
ಅದೇ 6 ತಿಂಗಳಾಗಿತ್ತು ಅವ್ರು ಮಾಡ್ಲಿಲ್ಲ ಅಂತ ಕಂಟೆಂಪ್ಟ್ ಆಗ್ತದೆ. ದಟ್ ಇಸ್ ವೈ ದೇ ಹ್ಯಾವ್ ಟೇಕನ್ ರಿವೆಂಜ್ ಅಗೇನ್ಸ್ಟ್ and then they have produced this order actually.
For conducting, before conducting the podi and duress, as you had submitted, it was required to verify the original records regarding the grant. Therefore, what the assistant commissioner was directed to do? Then carry out the work of podi and duress. How can you direct the Tahsildar to do that exercise? Direction has been issued to the assistant commissioner.
In the year 1954.
ಅಲ್ಲ, but see, he says ಮೂಲ ಮಂಜೂರಾತಿ ಕಡತ ಲಭ್ಯವಿಲ್ಲದಿರುವುದರಿಂದ, then what should happen then? ಮಂಡ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಕಚೇರಿಯಲ್ಲಿ That exercise cannot be done by the Tahsildar, sir. The direction has been given to the assistant commissioner. The assistant commissioner had to summon the original records, find out whether it's a temporary grant or a permanent grant, then pass necessary orders. No, I am directing the assistant commissioner to carry out the orders passed by this court properly. He is himself required to summon the original records, verify it in the presence of the petitioner, and thereafter issue necessary orders to the Tahsildar. In WP number 16948 of 2021. Stop. This court by order dated 20th of September 2021 accepted the submission of the learned AGA that before carrying out the exercise of Podi and Durst work, it was required to verify the genuineness of the claim regarding the grants made in favor of the petitioners. So therefore, this court directed the assistant commissioner to issue notice to all stakeholders, including the petitioners, arrive at a finding as regards the grant made, and thereafter communicate the said order to the Tahsildar within a period of 6 months from the date of receipt of the order. So, the Tahsildar was thereafter required to carry out the Podi and Durst work along with the additional director of land records. So, next para. However, when the assistant commissioner did not carry out the directions issued by this court within the stipulated time, the petitioners herein filed a contempt petition in CCC number 630 of 2022. So, during the course of the proceedings, it was submitted at the hands of the respondent assistant commissioner that he has passed necessary orders in compliance of the directions issued by this court, and therefore the contempt proceedings were dropped. So, next para. The orders passed by the assistant commissioner on 1/8/2022 has been challenged by the petitioners in this writ petition. So, learned counsel for the petitioner points out that instead of following the directions issued by this court, the assistant commissioner has delegated the power to look into the original records on the Tahsildar. Full stop. This is evident from the penultimate page of the impugned order, wherein the assistant commissioner has noticed that since the original grant register is not available, is not made available, the Tahsildar is directed to once again verify from the office of the Deputy Commissioner, Mandya district, and if it is found from the original grant register that what was granted to the petitioners was only a temporary grant, or a permanent grant, the Tahsildar may proceed to issue appropriate orders. Full stop. Next para. There is substance in the submission to the learned counsel for the petitioner. Full stop. This court had directed the assistant commissioner to call for the original records, verify the same in the presence of the parties, and thereafter issue necessary directions to the Tahsildar. Full stop. That exercise which was required to be done by the assistant commissioner, is now sought to be delegated to the Tahsildar. Full stop. This would not be in compliance of the directions issued by this court. Full stop. Next para. Consequently, the impugned order, insofar as the petitioner is concerned, is quashed and set aside. Full stop. The assistant commissioner is once again directed to comply with the directions issued by this court. In writ petition number so and so. Illado?
Village annexure of 68, operative portion at 71.
WP number 16948 of 2021, dated 20th of September 2021. By securing the original grant register, comma, Sagoli chit issue register, comma, mutation register, and all contemporaneous records, comma, verify the same in the presence of the petitioners, and if it is found that the grant made in favor of the petitioners was a permanent grant, comma, then he shall direct the Tahsildar and the assistant director of land records. Assistant or additional also?
Assistant Director, ADS.
Assistant director of land records to carry out the Fodi and duress work in respect of the land granted in favor of the petitioners within a stipulated time. Stop. Otherwise, comma, if it is found that the grant made in favor of the petitioners is only a temporary grant, comma, then the petitioners shall be permitted to make an application seeking permanent grant, and the competent authority shall pass necessary orders on the application that would be filed by the petitioners. Full stop. The entire exercise shall be completed by the assistant commissioner as expeditiously as possible, and at any rate within a period of 3 months from the date of receipt of a copy of this order. Full stop. Ordered accordingly.
Mother explained morning next week.
Okay.
Advocate Mother explained out of morning. Need to place it.
It is submitted on behalf of the learned counsel for petitioner that there has been a bereavement in the family. Full stop. Read this matter on 27th of January.
The writ of Mandamus in lordship, the petitioner representation dated 2/9/2021 to the third respondent. By virtue of the current RTC extract, this is the land wherein this is the restored land to the in-laws of the grantee, and according as per the annexure B, you know, and subsequently in the annexure C, the deputy commissioner order, it was dismissed. Subsequently, the RTC has been made in the name of petitioner in page number 22, annexure D, my lord. Based on that, the Mandamus was made. And subsequently, as per that, actually, to take the position of that, but the representation is given to the Tahsildar. They have not been considered from last 1.5 years. The annexure D, my lord, page number 20.
ಎಲ್ಲಿ ಓದ್ತಾ ಇದೀರಾ?
Page number 11.
11,
Annexure.
21. Subsequently, you have given representations at annexure F, 2022.
Yes, by the son of petitioners.
Which one you want to be considered now?
Annexure A is the page number 11. That's the petitioner's representation. That has been challenged.
Challenge.
That has been because annexure A is given by the petitioner and annexure F, my lord, is the F, E and F and G. They are the sons of this petitioner. Subsequently, they have remanded that. In spite of that, also they are not being touched.
And what is your prayers?
Well, my prayer is, my lord, because I have secured this land by virtue of the restoration, and the order has been made by the Assistant Commissioner in page number 12, annexure E, and subsequently Deputy Commissioner also has dismissed their appeal, purchase of appeal and restored the land.
You are the purchaser.
No, I am the legal head of granting. This land has been restored by the Assistant Commissioner, my lord, as per annexure E.
ಏನ್ರಿ ಹೇಳ್ತಾ ಇದೀರಾ ನೀವು?
Originally,
Annexure D, PTCL proceedings, you are the respondent there.
no, PTCL proceeding, I am the petitioners. PTCL proceeding.
ಮುನಿಯಪ್ಪ, ನೀವು ಮುನಿಯಮ್ಮ.
Lakshmaya Dasappa is my ancestors. They are the petition before the PTCL proceedings. And that was restored. And subsequently, the purchaser, the one Jakub, the entire land, one his purchase, page number 15, annexure C. That was Deputy Commissioner, before the Deputy Commissioner assist the appeal. That was also dismissed. And subsequently, the land is restored in my name. And accordingly, the RTC has come in my name in page number 22, annexure D. In all my legal lists, including myself. And subsequently, there was a Haddubas was made as per annexure E. Subsequently, now that by virtue of this Haddubas and all, there is an encroachment and because the neighbors of that, as per the Haddubas, they are disturbing my social sketch. In view of that, I given
What will the revenue authorities do?
my lord,
If there is encroachment at the hands of a private person, your neighbor, you will have to approach civil court.
I do agree, my lord.
How can you ask the revenue authorities to come and remove the encroachment? What powers do they have? The land has been encroached by a private person,
Neighbor, please.
Neighbor, you will have to approach the civil court.
My lord, there is a Haddubas is given made by this.
ಹೌದು ಸರ್, ಅವರು ಕಾನೂನು ಪ್ರಕಾರ ಹದ್ಬಸ್ತ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ದಾರೆ. Now it is found that your neighbor has encroached on some portion of your land. What is the remedy? You will have to go to the civil court.
At least my application fee.
ಏನ್ ಮಾಡೋದಕ್ಕೆ ಡೈರೆಕ್ಷನ್ ಕೊಡಬೇಕು? If a direction has to be given by this court, there has to be a duty cast on that officer in the statute. Please point out. ಹಂಗಲ್ಲ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಕೋರ್ಟ್ಗೆ ಇಷ್ಟ ಬಂದಂಗೆ ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಡಕ್ ಬರೋದಿಲ್ಲ. A mandamus can be issued only when there is a law in your favor which enables you to seek a direction to the concerned officer. ಬರ್ಕೊಳ್ಳಿ. Learned AGA takes notice for all the respondents. Next para. The petitioner is seeking a writ of mandamus directing the respondent authorities, more particularly the third respondent Tahsildar, Bangalore East Taluk.
I'll just file the memo with permission to file before the appointment.
Want to withdraw the petition? After arguing for some time, learned counsel for the petitioner seeks leave of this court to withdraw the writ petition and pursue his remedy before the competent civil court. Please stop. placing the submission of the learned counsel for petitioner on record, the writ petition stands dismissed as withdrawn, with liberty reserved to the petitioner to approach the competent civil court.
The petition filed for the relief of Mandamus. Consider the annexes G, H and J, the representation given the petitioner to the respondent number 2 and 3. That this survey number 26/2A, a measuring trust is the land belongs to the father of the petitioner. He died in 1995. After death, it was Katha's land to Kenchamma. Kenchamma also died in 2017. This land was vested with the government or the declaring as a Gramatana. Now it was vested with the government. So he's seeking the compensation for the same. So he given a representations. So that is not considered by the
Compensation.
compensation for the land.
Anga, this is not a KLR matter.
Yella is vested with the government for under the section 38 of the Land Reforms Act. And declared as a Gramatana.
Where is all that information?
But annexure D, the inquiry notice issued by the Assistant Commissioner.
Vicharana notice. What is?
Chitraduರ್ಗ ಕಸಬಾ ಹೋಬಳಿ ಗೋನೂರು ಕಂದಾಯ ಗ್ರಾಮ ಸಾಸಲಹಟ್ಟಿ ಮುಜರೆ ಗ್ರಾಮ ಗೋನೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 26A ರಲ್ಲಿ 8 ಎಕರೆ 20 ವಿಸ್ತೀರ್ಣವಿದ್ದ ಸದರಿ ಗ್ರಾಮವನ್ನು 2E ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಿರುವಂತೆ ಕಂದಾಯ ಇಲಾಖೆಗಳಲ್ಲಿ ಸರ್ಕಾರ ಎಂದು ನಮೂದಿಸುವ ಬಗ್ಗೆ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಚಿತ್ರದುರ್ಗ ಜಿಲ್ಲೆಯವರ ನೋಟಿಫಿಕೇಶನ್ ನಂಬರ್ LNDCTA 2E
ನಂಬರ್ ಎಲ್ಲ ಓದಬೇಕಾಗಿಲ್ಲ ನೀವು. ನೆಕ್ಸ್ಟ್ ಓದಿ.
ಸರ್ಕಾರಿ ಸುತ್ತೋಲೆ ನಂಬರ್ 85 ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಈ ಮೂಲಕ ನಿಮಗೆ ತಿಳಿಯಪಡಿಸುವುದೆಂದರೆ ಚಿತ್ರದುರ್ಗ ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಗೋನೂರು ಕಂದಾಯ ಗ್ರಾಮದ ಸಾಸಲಹಟ್ಟಿ ಮುಜರೆ ಗ್ರಾಮವು ಗೋನೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 26/2A ನಲ್ಲಿ 8 ಎಕರೆ 20 ಗುಂಟೆ ಎಕರೆ ವಿಸ್ತೀರ್ಣವಿದ್ದು ಸದರಿ ಮುಜರೆ ಗ್ರಾಮ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಚಿತ್ರದುರ್ಗ ಜಿಲ್ಲೆ ಇವರು ಉಲ್ಲೇಖ 1ರ ಪತ್ರದಂತೆ ಸಾಸಲಹಟ್ಟಿ ಕಂದಾಯ ಗ್ರಾಮ ರಚನೆಗೆ 2E ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಲಾಗಿರುತ್ತದೆ. ಪ್ರಯುಕ್ತ ಕಸಬಾ ಹೋಬಳಿ ಗೋನೂರು ಗ್ರಾಮದ ಸಾಸಲಹಟ್ಟಿ ಮಜರೆ ಗ್ರಾಮ ಗೋನೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 26/2A ರಲ್ಲಿ 8 ಎಕರೆ 20 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣವನ್ನು ಕಂದಾಯ ದಾಖಲೆಗಳಲ್ಲಿ ಸರ್ಕಾರ ನಿರ್ಮಿಸಲು ತಮ್ಮ ಆಕ್ಷೇಪಣೆಗಳ ಇದ್ದಲ್ಲಿ ಅಗತ್ಯ ದಾಖಲೆಗಳೊಂದಿಗೆ 6/5/2000 1 ಗಂಟೆಗೆ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಖುದ್ದು ಹಾಜರಾಗಿ ತಮ್ಮ ಲಿಖಿತ ಹೇಳಿ ಸೂಚಿಸುವುದು. Is appeared and no given no objection for the visited the land, but it is not only compensation for that land.
ಯಾವ ಪ್ರಾವಿಷನ್ ಕೆಳಗಡೆ ಕೇಳ್ತಾ ಇದ್ದೀರಾ ಸರ್ ನೀವು? ಪ್ರಾವಿಷನ್
Like it was vested with the government section 38.
Why did you agree?
Because some peoples are deciding there some persons. So it was declared that they are given some application to allot the sites.
So therefore you should have put that condition. Under which provision, what directions can be given now?
Just considering this representation under concerned law.
ಯಾವ ಅದನ್ನೇ ಕೇಳ್ತಾ ಇರೋದು. Which law?
The land was taken and declared as a Gramatana. So they are to give compensation for
Under the Land Acquisition Act.
Plus acquired and land acquisition. Then only vested with the government under section 38 of the Land Reforms Act.
Land Reforms Act ಎಲ್ಲಿದೆ? Where have they mentioned?
Annexure E, the notice, the communication letter issued by the Deputy Commissioner to the Assistant Commissioner. ಚಿತ್ರದುರ್ಗ ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಗೋನೂರು ಗ್ರಾಮದ ಈ ಸರ್ವೆ 26/2 ದಾಖಲೆ ರಹಿತ ಜನವಸತಿ ಕೇಂದ್ರವು ಖಾಸಗಿ ಮಾಲೀಕತ್ವದ ಸರ್ವೆ ನಂಬರ್ ಇರುವುದು ಕರ್ನಾಟಕ ಭೂ ಸುಧಾರಣಾ ಕಾಯ್ದೆ 1961 38 ಅನ್ವಯ ಸರ್ಕಾರದ ಹೆಸರಿಗೆ ನಿಯುಕ್ತಿಗೊಳಿಸಿ ಹಾಗೂ ಪರಿಹಾರ ಕೊಡುವಂತೆ ಕೋರಿರುವ ಬಗ್ಗೆ ಶ್ರೀ ಗುರುಪಾದಪ್ಪ ಬಿನ್ ಲೇಟ್ ಚಿಕ್ಕವೀರಪ್ಪ ಸಾಸಲಹಟ್ಟಿ ಗ್ರಾಮದ ಮನವಿ.
ನಿಮ್ಮ ರೆಪ್ರೆಸೆಂಟೇಷನ್.
ಎಸ್.
Section 38, you are referred to section 38 of the Land Reforms Act. That is dwelling houses of agricultural laborers, etc. If in any village, an agricultural laborer is ordinarily residing in a dwelling house on a land not belonging to him, then notwithstanding anything contained in any other law, but subject to subsection 2 and 3, such dwelling house along with the site thereof and land immediately appurtenant thereto and necessary for its enjoyment shall, on the date of publication of the Karnataka Land Reforms Amendment Act 1978 in the official gazette, vest absolutely in the state government, free from all encumbrances, and the agricultural laborer shall be entitled to be registered as owner thereof. ಮತ್ತೆ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ತಾರೆ ನಿಮ್ಮ ಹೆಸರಲ್ಲೇ.
Land owner, not a agricultural laborer. And land owner. The petitioner is a land owner.
Then you will have to approach the competent court to seek a declaration that that this is your private land and they could not have issued that notification under this provision. You have not challenged that one. You are required to challenge that.
Notification issued in 2021 by the Deputy Commissioner. There is a reference in the Annexure D.
What are you seeking now? Compensation.
Compensation, only compensation. Given the compensation, let them give the katas to the allottees. That is the representation given by the petitioner.
Learned AGA takes notice for all the respondents. Learned counsel for petitioner is directed to serve a copy of the petition on the learned AGA. Stop. Next para. It is the contention of the petitioner that is the owner.
That's his father.
Huh?
His father. The land belongs to father of this petitioner.
He is the owner of 8 acres and 20 quintas of land in resurvey number 26/2A of Gonur village, Chitradurga Taluk and district, having inherited the same from his father, Sri Chikkavirappa. However, it appears that the Deputy Commissioner, Chitradurga district, issued a notification dated 6/12/2021 in LND CTA bracket 2E close CR-69/2122. Consequent to a government order bearing number KE 635 835 KV 2017 and KE 843 KV 2017 etc. Calling upon the petitioner's mother, Srimati Kenchamma, to file any objections for the notification issued by the Deputy Commissioner, whereby the entire extent of 8 acres and 20 guntas of land in survey number 26 for 2A was requisitioned for notifying the same as government land. Full stop. Learned Counsel submits that the petitioner's mother and the petitioner have given their no objection.
The petitioner mother is already dead on that time. Operation is she
That
is
the
dead
petitioner
70.
gave no objection, comma, since the petitioner's mother had died much prior to the notice dated 27/4/2022 at Annexure D issued by the Deputy Commissioner. Full stop. Now, however, the petitioner is seeking compensation in lieu of the land being utilized for a public purpose. Full stop. Next para. On going through the provisions contained in section 38 of the Karnataka Land Reforms Act, 1961, this court is not convinced that the petitioner would be entitled to seek for compensation, since in terms of the said provision, wherever agricultural laborers are in occupation of small pieces of land and the same is are in occupation of dwelling houses, small pieces of land are in occupation of dwelling houses and appurtenant lands the state government is empowered to notify the said lands to absolutely vest with the state government, free from all encumbrances, and the agricultural laborer shall be entitled to be registered as owner thereof. So, next para. Nevertheless, the respondent, Deputy Commissioner, Chittorgarh district, is required to give written instructions to the learned HCGP regarding the consideration of the representation made by the petitioner seeking compensation for use of his land. Full stop. Next para. Release this matter on 25th of January
Madam, seeking
Please take instructions.
interim order of not issuing the kata unless until dispose of the respondent, not issue the kata.
ಬರೋದಿಲ್ಲ sir.
Mandamus against the respondent number. Vote please, my lord. The petitioner has purchased the property bearing survey number 22 measuring 4 acres. And the revenue entries have been effected in his name. And the said entries have been questioned by one of the vendor before the assistant commissioner by filing the revenue appeal before the assistant commissioner produced the annexure deeply.
You purchased in the year 1975.
Please, my lord.
Huh?
Please.
75. Your name was entered in the land records by
90.
huh?
90.
90 by virtue of MR number.
MR number 3 of produced the annexure C, please, my lord. And this entry has been questioned before the assistant commissioner, one of the vendor, please, my lord, it is produced at annexure D. And the assistant commissioner was held that, please, my lord, the land was purchased and ultimately the appeal was dismissed. And while filing the appeal, please, my lord, at the initial stage, the stay order has been granted. That has been mentioned in column number 11, please, my lord, the stay order of the assistant commissioner. And as per the final orders, please, my lord, the orders remains in the column number 11. And this order has been challenged before the deputy commissioner, please, my lord, by filing the revision petition. Ultimately, the revision petition also dismissed. And the revision petition, the stay was granted. The said entry was mentioned in the column number 11 of the RTC, please, my lord. Now the process have been completed, please, my lord. I have given representation to the Tahsildar to remove the stay orders mentioned in page number 38, please, my lord. In the column, please, my lord, the stay orders, the interim stay orders have been mentioned in the column number 11. And my representation at produced that annexure here, please, my lord, for removal of those are the stay orders mentioned in column number 11. That representation dated 25/2022, please, my lord. And the Tahsildar has not taken any initiative action against that process and not deleted the names, the stay orders mentioned in the RTC, please. That's why the writ of mandamus will arise against the respondent.
Barkal. Learned HCGP takes notice for all the respondents. Learned counsel for the petitioner submits that the name of the petitioner was entered in the land records. In terms of MR number 3 of 1990-91. Consequent to the petitioner acquiring the land in question, that is 4 acres and 4 guntas of land in survey number 22 of Rampura village, Sulibele Hobli, Hoskote Taluk, under a registered sale deed dated
6th April 1975.
Six 11/1975. Stop. However, one R.A. Muniyappa, son of Annayappa, had challenged the mutation entry made in favor of the petitioner before the assistant commissioner, Doddaballapura subdivision in RA bracket H close 103 of 2006-2007. So initially, the assistant commissioner had passed an interim order of stay of the mutation entry made in favor of the petitioner, and the same was entered in column number 11, please, of the RTC. So, nevertheless, the appeal was finally dismissed by the assistant commissioner on 28/3/2008. So, thereafter, the said R.A. Muniappa approached the deputy commissioner by filing a revision petition 43/2008-2009. Stop. The deputy commissioner too had passed an interim order in favor of the revision petitioner, and the same was again noted in column number 11 of the RTC. Full stop. The revision petition was dismissed by the deputy commissioner by order dated
16/2/2015.
16/2/2015. Full stop. The grievance of the petitioner is that in spite of the dismissal of the appeal and the revision, the note put up in column number 11 consequent to the interim orders passed by the two authorities are still continued, and even after representations are given by the petitioner, the same is not removed. Full stop. Next para. There is sufficient force in the submission of the learned counsel for petitioner. Full stop. When once the authorities, the revenue authorities, dismissed the appeal and the revision petition, the interim orders merge with the final order, and therefore the entries made in column number 11 were required to be removed. Full stop. Next para. Consequently, the petition stands disposed of. The specific direction to the fourth respondent, Tahsildar, Hoskote Taluk, to remove the entries made in column number 11 in the RTC pertaining to the land in question, which were entered consequent to the interim orders passed by the assistant commissioner as well as the deputy commissioner. So, the entries shall be removed as expeditiously as possible, and at any rate within a period of 6 weeks from the date of receipt of a copy of this order.
It's a writ of certiorari, my lord, to pass the annexed D, my lord, passed by the deputy commissioner, Bengaluru district. The case of the petition is, my lord, the petitioners acquired the land through land order passed by the land tribunal to an extent of 1 acre 32 guntas, my lord. The total extent of the land is 2 acres 16 guntas, my lord, including 4 guntas of the Kharab land. So I acquired that 1 acre 32 guntas, my lord. So remaining is only to an extent of 24 guntas, my lord. So when there is a difference in tally in column number 3 as well as column number 9 of the RTC, I prepared an appeal before the assistant commissioner. The assistant commissioner, after pursuing all the documents, specifically passed an orders that so I am entitled for 1 acre 32 guntas and other entitled only for 24 guntas, my lord.
Yaro.
Yes, the third respondent here in this case, Ramakrishna Reddy.
You are only concerned with 1 acre 32 guntas.
Please, my lord.
Ah.
So if you, as per this order passed by the deputy commissioner, my lord, the third respondent is now entitled for 31 guntas, my lord, against to the 24 guntas. So as per the annexure C, my lord, the order passed by the assistant commissioner has clearly stated that, my lord, just read the operating portion of that order, my lord, just in page number 36, my lord. Even though the land was granted to me or to the third respondent, my lord, based upon the adverse, only the exact measurement should be calculated by the concerned authorities. So upon that, the assistant commissioner clearly passed orders in page 36, last para, my lord. The Tahsildar Anekal Taluk, Anekal shall take necessary actions to affect the 4D jurisdiction of the extent of lands which is actually in possession and enjoyment of the applicants and the third respondent herein, since the order of the land tribunal confirming occupants' rights, right in respect of the extent of land is always subject to the 4D jurisdiction. So that after 4D of the lands held by them will tally with the extent of the land between column number 3 and 9 for the artist. By virtue of the order passed by the assistant commissioner, the Tahsildar required to hold a jurisdiction, my lord. The order was set aside by the deputy commissioner as per annexure D, my lord. So therefore, the order passed by the deputy commissioner is illegal controversy. If you consider the order passed by the deputy commissioner, my lord, the third respondent has holding 31 guntas. Against is having the right only to an extent of 24 guntas.
Please read ink page number 17. The last page of the order of the land tribunal. Para 1 in that internal page number 3. ವಾದಿಗಳ ಮತ್ತು ಪ್ರತಿವಾದಿಗಳ ಹೇಳಿಕೆ.
In page number 17.
Yes.
ವಾದಿಗಳ ಮತ್ತು ಪ್ರತಿವಾದಿಗಳ ಹೇಳಿಕೆ ಹಾಗೂ ಕಡತದಲ್ಲಿ ಲಭ್ಯವಿರುವ ದಾಖಲಾತಿಗಳ ಪರಿಶೀಲನೆಯಿಂದ ಗುಲಿಮಂಗಳ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 4ರಲ್ಲಿ 2 ಎಕರೆ 20 ಗುಂಟೆ ಜಮೀನಿಗೆ ಲೇಟ್ ಲಕ್ಷ್ಮೀನಾರಾಯಣ ರೆಡ್ಡಿ ಅವರು ಈ ಹಿಂದೆ ಭೂ ನ್ಯಾಯ ಮಂಡಳಿಯ ಅಧಿಭೋಗದಾರನಾಗಿ ನೋಂದಾಯಿಸಿದ್ದು ಹಕ್ಕುಪತ್ರ ಸಹ ವಿತರಣೆ ಆಗಿದ್ದು ಸರ್ವೆ ನಂಬರ್ 5ರ ಜಮೀನು ಮಂಜೂರಾತಿ ಆಗಿಲ್ಲದ ಕಾರಣ ಲೇಟ್ ಲಕ್ಷ್ಮೀನಾರಾಯಣ ರೆಡ್ಡಿ ಅವರ ಗೇಣಿ ಅರ್ಜಿ ತಿರಸ್ಕರಿಸಿದ್ದು. ತದನಂತರ ಲೇಟ್ ಲಕ್ಷ್ಮೀನಾರಾಯಣ ರೆಡ್ಡಿ ಅವರು ವಾರಸುದಾರರು ಆನೇಕಲ್ ತಾಲೂಕು ಸರ್ಜಾಪುರ ಹೋಬಳಿ ಗುಲಿಮಂಗಲ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 5ರಲ್ಲಿ ಜಮೀನು ತಹಸೀಲ್ದಾರ್ ಆನೇಕಲ್ ತಾಲೂಕು ಆದೇಶ ಸಂಖ್ಯೆ ಸೋಣಿಸುವ ಪ್ರತಿವಾದಿಗಳ ಮರು ಮಂಜೂರಾತಿ ಆದ ನಂತರ ಅದಾದ್ಮೇಲೆ ನಾವು ಹೈಕೋರ್ಟ್ ಬಂದಿದ್ವಿ. ಸರ್ ಹೈಕೋರ್ಟ್ ರಿಟ್ ಪಿಟಿಷನ್ ಕೇಮ್ ಟು ಅಲೌ and it has been remanded back to the land tribunal. So thereafter only the land tribunal has granted land to me, my lord, in the year 2002. Subsequent order passed by this honorable court in WP number 29439/1994 wide dated 14/9.
Please read why. Though the claim was made in respect of 2 acres and 20 guntas.
I am expecting only that 1 acre.
Yes, sir. Please read.
ಆನೇಕಲ್ ತಾಲೂಕು ಆದೇಶ ಅಂತ ಸೋ ಪ್ರತಿವಾದಿಗಳಿಗೆ ಮಂಜೂರಾತಿಯಾದ ನಂತರ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಸೋಣಿಸು ಹಾಗೂ ಗೂಳಿಮಂಗಲ ಗ್ರಾಮ ಸರ್ವೆ 5ರಲ್ಲಿ ಒಟ್ಟು 2 ಎಕರೆ 16 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣವಿದ್ದು ಪಹಣಿ ಕಾಲಂ 12/2ರಲ್ಲಿ ವಾದಿ ಲಕ್ಷ್ಮಣ.
Are we concerned with survey number 5 or 4?
5, my lord.
5,
my lord. ಲಕ್ಷ್ಮೀ ರೆಡ್ಡಿ ಅವರು ಹೆಸರು 1971, 72ರಿಂದ 73, 74ರವರೆಗೆ ದಾಖಲಾಗಿರುವುದು ಸಹ ಕಂಡು ಬರುತ್ತದೆ. ಅಲ್ಲದೆ ಪ್ರಶ್ನಿತ ಸೋಣಿಸು ಆರ್ಡರ್ ಆನೇಕಲ್ ತಾಲೂಕು ಸರ್ಜಾಪುರ ಹೋಬಳಿ ಗುಳಿಮಂಗಲ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 5ರಲ್ಲಿ 1 ಎಕರೆ 32 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣದ ಅಳತೆಗೆ ಒಳಪಡಿಸಿ ಜಮೀನಿಗೆ ಕರ್ನಾಟಕ ಭೂ ಸುಧಾರಣಾ ಕಾಯ್ದೆ 1961ರ ಕಲಂ ಸೋಣಿಸು ಪ್ರಕಾರ ಲೇಟ್ ಲಕ್ಷ್ಮೀ ರೆಡ್ಡಿ ಅವರ ವಾರಸುದಾರರಾದ PL Jairam Reddy. Jairam Reddy is the husband of the first petitioner, father of the second petitioner, and PL Venugopala Swami, the petition number 3 here in this case, my lord. Adipuranaagi nondaಯಿಸಲು ಭೂ ನ್ಯಾಯ ಮಂಡಳಿಯಲ್ಲಿ ಆದೇಶಿಸಲಾಗಿದೆ. It's very clear, my lord. The total extent is 2 acres 16 guntas. If I am entitled, if by virtue of the orders only 1 acre 32 guntas. So rest of the only 24 guntas. However, the deputy commissioner passed an order to an extent of 31 guntas, exceeding the 7 guntas. ಒಂದು ಕಡೆ 32 ಗುಂಟೆ ಅಂತ ಹೇಳ್ತಾರೆ, ಇನ್ನೊಂದು ಕಡೆ 31 ಗುಂಟೆ ಅಂತ ಹೇಳ್ತಾರೆ, ಖರಾಬ್ 4 ಗುಂಟೆ ಅಂತ ಹೇಳ್ತಾರೆ, ಖರಾಬ್ 8 ಗುಂಟೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. It is all mistake committed by the officers of the Tahsildar, my lord. So after duress only, as per the order passed by the assistant commissioner, as per annexure C, generally the exact picture to whom in possession of the property. Suppose I am in possession of the property by virtue of the orders of the land tribunal, I am ready to accept the same. Thereafter, we also conducted a survey also, my lord.
You approach the assistant commissioner.
Please, my lord. Yes, my lord. There is a variation of the tally in column number 3 as well as column number 9 to reduce the extent of the third respondent here from 31 guntas to 24 guntas. ಒಂದ್ ಕಡೆ 8 ಗುಂಟೆ ಹೇಳ್ತಾರೆ, ಒಂದ್ ಕಡೆ 7 ಗುಂಟೆ ಹೇಳ್ತಾರೆ. ವೇರಿಯೇಷನ್ ಎಕ್ಸಾಕ್ಟ್ ದುರಸ್ತಿ ಆದ್ಮೇಲೆ ಕ್ಲಿಯರ್ ಪಿಕ್ಚರ್ ಗೊತ್ತಾಗುತ್ತೆ ಸರ್.
Was there one more order passed by the land tribunal in favor of
R3.
C. Nanjareddy?
Yes, C. Nanjareddy is the father of the third petition. Third
Was
respondent.
there one more order passed by the land tribunal?
ಅದು ಆಕ್ಚುಲಿ ಇಲ್ಲ. ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ, ಬೋಗಸ್ ಅಂತ ಹೇಳ್ಕೊಂಡು ಹೋಗ್ತಾ ಇದ್ದಾರೆ. ಅಸಿಸ್ಟೆಂಟ್ ಆರ್ಡರ್ ಕಮಿಷನ್ ಅಲ್ಲಿ ಆಪರೇಟಿಂಗ್ ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಇಟ್ ಇಸ್ ಬೋಗಸ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಂತ ಹೇಳ್ತಾ ಇದಾರೆ. ಆಮೇಲೆ ಈ ಫೋರ್ತ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದಾರಲ್ಲ ಸುಮ್ಮನೆ ಚಂದ್ರಮೌಳಿ, ಅವರೊಂದು ಎಂಡರ್ಸ್ಮೆಂಟ್ ಕ್ರಿಯೇಟ್ ಮಾಡ್ಕೊಂಡು 2 ರಿಟ್ ಪಿಟಿಷನ್ ಆಗಿದೆ. ರಿಟ್ ಪಿಟಿಷನ್ ವಿತ್ ಕಾಸ್ಟ್ ಆಫ್ ರೂಪೀಸ್ 10,000 ಡಿಸ್ಮಿಸ್.
But that has been noticed by the authorities.
Please, my lord, it was noticed, but herein I am not a party in that proceedings, even if it is any.
Even otherwise, it is dismissed according to you.
Yes, my lord. Yes, my lord.
Even after noticing that, why such an order has been passed then?
ನಾನು ಎಲ್ಲ ಒಂದ್ ಹೇಳಿಕೆ ಕೊಟ್ಟಿದ್ದೇನೆ ಅಂತ ಲ್ಯಾಂಡ್ ಟ್ರಿಬ್ಯುನಲ್ ಅವ್ರ ಕೇಸಲ್ಲಿ, ಅವ್ರ ಕೇಸ ಇಲ್ಲ 1001 ನಮ್ದು. ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು LRF ಕೇಸಲ್ಲಿ. ಆ ಕೇಸ್ ನಂಬರ್ ಅವ್ರು ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಮೆನ್ಷನ್ ಮಾಡ್ತಾ ಇಲ್ಲ. ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಮಾಡಿದ್ರೆ ಕ್ಲಿಯರ್ ಆಗಿ ಗೊತ್ತಾಗುತ್ತೆ ಸರ್. It leads to multiple set of proceedings.
Learned HCGP takes notice for response number 1 and 2. Issue notice to response number 3 and 4. Learned counsel for petitioner is directed to serve a copy of the petition on the learned HCGP.
Meanwhile, annexed D may be statement. Otherwise, one submission.
No. That entry has been there for a long time.
No, my lord.
Was there an interim order passed by the assistant commissioner and the deputy commissioner?
Yes, my lord. Yes,
Please point out. ತೋರ್ಸ್ರಿ.
ಅಲ್ಲ, ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಆರ್ಡರ್ ಶೀಟ್ ಇಲ್ಲ ಸರ್ ನಮ್ಮ ಹತ್ರ.
ಬರೋದಿಲ್ಲ. Yes.
ಅಲ್ಲ, ಡೇಟ್ ಮೇ ಬಿ ಫಿಕ್ಸ್. Date may be. Issue emergency notice to the at least respondent.
Emergent notice.
Please.
Of Mandamus, my lord.
Yes.
With the name of work from column number 11.
Remove the name of.
Works. These lands were regularized and granted to person who were in unauthorized cultivation. That was subject matter of a writ petition by the work board before this court, which they lost, a writ appeal, which they lost. My lords, may kindly come to page 214, my lord. The order of the Supreme Court.
Learned HCGP takes AGA takes notice for response number 1 to 5. Who appears for this work board?
Good, Ali Patil, my lord, but I don't know, but my lords may say standing counsel, my lord.
P.S. Mali Patil. He directed to take notice for response number 6. Learned counsel for the petitioners is directed to serve 2 sets of copies of the petition on learned counsel for response number 6 and a copy on the learned AGA. Yes.
2 weeks someday. 2 weeks someday, Mandamus.
Yes.
Which challenges the endorsement issued by the second respondent. Annexure G, page 16. And the beneficiary under the will, annexure D, my lord. I applied for I am the beneficiary of the will, annexure D, to the extent of 24 cents. I made a representation to the second respondent into the mutation, for which he is refused on the ground that the will is not probated. That is annexure G, page 16. should be probated before the court of law. That's what
Hmm.
the endorsement he has given.
Hmm.
Back Succession Act,
Hmm.
section 222
Ah,
is very clear, my lord. Publicity is required in case of only the executor is appointed in the will.
even otherwise, are you a family member?
The author of the will is my mother's own sister. She is issueless. I have protected her during lifetime.
Ah,
That's why out of 46 cents,
Hmm.
24 cents was bequeathed in my favor.
Hmm.
Is issueless.
Hmm.
222 is very clear.
Hmm.
It is only in case of executor is appointed. It should be probated.
Hmm. Any decided case? Will need not be registered. $128 earlier. Yes. Huh? Huh? Hmm. Hmm. ಅದು ಬೇರೆ. That is different. See, even in case of an inheritance, there is mention of the word inheritance. ಏನ್ ಮಾಡ್ತಾರೆ? They only go and orally report. It is accepted. They in fact call for objections. So you could have called for objections. Correct. And he has not noted that there is any dispute raised by any person.
Yes,
Alva.
simply kept the file. without-
Any decided case?
222 prakara probate not necessary.
Huh?
Even otherwise, this one ruling is only the properties which comes under section 57(8)(e). And only probate is required. What is it? 222 is very clear, only executor is appointed. As the property comes under the 57 of the Indian Succession Act. Much clearer, madam. One more.
What is this outside the territories mentioned in section
57A.
57A?
Yes, madam.
What is that?
That is 57A. Properties comes under.
All wills and codicils made by any Hindu, Buddhist, Sikh or Jain on or after the first day of September 1970 within the territories which at the said date were subject to the Lieutenant Governor of Bengal or within the local limits of the ordinary original civil jurisdiction of High Courts of Judicature at Madras and Bombay. And all such wills and codicils made outside those territories and limits so far as relates to immovable property situated within those territories or limits. BL Bartala.
Those
Okay.
Karnataka comes.
Huh?
This is Karnataka.
Allah BLA shall apply to all such wills and codicils made outside those territories.
Made outside those limits so far as individual properties within those limits and to all wills and codicils made by Hindu, Buddhist, Sikhs and Jains or after the first 27 to which those provisions are applicable. But ಇಲ್ಲಿ ರೂಲಿಂಗ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಅಪ್ಲೈ ಆಗೋದಿಲ್ಲ ಅಂತ. ಒನ್ ಮಾರ್ ರೂಲಿಂಗ್ ಐ ಹ್ಯಾವ್ ಗಿವನ್. Para 12, second ruling, para 12 ಅಲ್ಲಿ. Para 12. Court below in the present case no doubt has been correct in opinion that if the probate is not obtained, the document may have to be proved in every proceeding where it is relied. But that could not be the reason to refuse the application of the revision petition for appointment of an expert commission to compare this.
We are not concerned with that one.
No, we are not concerned. Later, subsequently, the provisions of obtaining the probate may not be applicable in the cases of wills executed by a Hindu. If the said will does not come within the clause of wills specified section 57A, AB. 57 specifies the wills to which provisions may apply. Wills made by a Hindu, Buddhist, Sikh or so and so after the first day of September 1870 within the territories which are subject to the Lieutenant Government of Bengal or within the local limits of the ordinary original civil jurisdiction of high courts of Madras and Bombay, or in cases where wills are made outside those territories to the extent they relate to the properties situated within the limits of territories of Bengal and Madras and Bombay, and not otherwise, not others. In the case of so and so, again, they have referred. Reading clause A of 57 reads with section 213 makes it clear that it could only apply to cases where property or properties are situated in the territories mentioned in clause A of section 57 of the Act. Clause A of the 57 Act only it refers.
On or after the first day of January 1927, to which provisions are not applicable.
Article 57A only applies. That's what this ruling says.
But what about C then? 57C.
But here, reflection only A is applicable. That's what 213 read with section 15 to the 57A. That's what this the ruling precisely states in para 2N. Subsequently, also the reading of clause A of section 57 read with section 213 makes it clear that it would only apply to cases where the properties bequeathed are situated in the territories mentioned in clause A of section 57 of the Act. Apart from this, my lord, 222 is very clear section.
See, we'll call it once again next week. Huh?
Monday.
Learned AGA takes notice for all the respondents.
18th of May.
Learned counsel for petitioner is directed to serve a copy of the petition on the learned AGA. Release this matter on
18th of May.
18th of January.
The petitioner here in Manoj was granted land Manoj bearing survey number 35 Manoj measuring to an extent of 3 acre 20 guntas. The resolution was passed by the land grant committee Manoj at Annexure C Manoj page 22 Manoj on 17th of February 2018 Manoj. Subsequently Manoj in the month of March Manoj Sagoli cheat was also issued Manoj. However Manoj in the revenue entries Manoj the name of the petitioner Manoj has not been entered Manoj by the Tahsildar, third respondent Tahsildar Manoj. In spite of the fact that Manoj, the grant was made Manoj way back in the year 2018 Manoj. Sagwali cheat Manoj was also subsequently issued Manoj at Annexure F Manoj. Logic kindly peruses Manoj. Page 34 Manoj. Annexure G Manoj, page 34. This Sagwali cheat Manoj was issued by the Tahsildar Manoj in respect of the granted land. And Manoj, Annexure J Manoj is the letter addressed by the Assistant Commissioner, my lords, to the Tahsildar. To take further steps, my lords, in terms of the grant and Saguli cheat, my lords, issued in favor of the petitioner. However, my lords, till date, my lords, no steps have been taken by the Tahsildar, my lords, to enter the name of the petitioner, my lords, in the revenue records in respect of the granted land, my lords. Annexure H is the representation, my lords, given by the petitioner, my lords. I've sought for a direction, my lords, to the third respondent Tahsildar, my lords, fourth respondent Tahsildar, my lords, to affect the name of the petitioner in respect of the granted land.
Learned HCDP takes notice for all the respondents. Next para. The grievance of the petitioner is that her name is not being entered in the land records. Although a Sagavali chit has been issued by the fourth respondent Tahsildar on
21/3/2018.
21/3/2018, as found at Annexure G. So, learned counsel for the petitioner would further draw the attention of this court to a communication dated 14/2/2022 at Annexure J, made by the Assistant Commissioner, Tumkur Subdivision, directing the Tahsildar to take steps to enter the name of the petitioner in the land records. So, in spite of such directions, the fourth respondent Tahsildar has not entered the name of the petitioner in the land records. So, next para. The prayer in the writ petition is to issue a writ of Mandamus directing the fourth respondent Tahsildar to consider the representation dated 23/12/2022 at Annexure H to enter the name of the petitioner in the land records in respect of 3 acres and 20 guntas of land in survey number 35 of Tippanahalli village, Kasba Hobli, Tumkur Taluk. Next para. Having regard to the prayer made in the writ petition and the submissions of the learned counsel for the petitioner, this court is of the considered opinion that the fourth respondent Tahsildar is duty bound to consider the representation of the petitioner, and after verifying from the original records regarding the genuineness of the grant said to have been made in favor of the petitioner, the Tahsildar shall proceed to enter the name of the petitioner in the land records. Full stop. The entire exercise shall be completed as expeditiously as possible and at any rate within a period of 2 months from the date of receipt of a copy of this order.
Right.
Pass over.
That is RSA. I have referred that also in the petition. Let him take notice, then we will. I have produced that document also. RSA. That is my grievance is that it is not considered by the civil courts. It is the exact grievance, my lord.
What is the prayer in the writ petition?
Prayer is quash the order of the land appellate tribunal.
Appellate tribunal.
Appellate tribunal 17A proceedings ali competent authority granted the land in the name of the petitioner. It was challenged by the fourth respondent before the appellate tribunal. Appellate tribunal quash the order of the grant in favor of petitioner. Where, my lord, the petitioner advocate is not appeared before the tribunal, my lord, unable to put forth these already aspects. That is my prayer in this petition.
When was the order of the appellate authority passed? Appellate tribunal passed?
31/3/2015, Annexure M, my lord.
2015.
Yes, my lord.
And you are challenging that in this writ petition?
Yes, my lord.
After 8 years.
Bangalore camp, they conducted the hearing, my lord.
The advocate has not appeared. 22 ವರೆಗೆ ಗೊತ್ತಾಗಿಲ್ಲ ಇವರಿಗೆ. Now that RTC based on that order, the fourth respondent gave application during 2022. Then this petitioner came to know that the order of the appellate tribunal. Since ancestor, the land was in his possession, my lord. Now there is no other than change in RTC. There is no other effect, my lord. He has constructed the house also now. Contestingly,
His suit was filed by whom? Only permanent injunction.
The respondent is actually he died on 15/8/2019. Petition is also very
it will take steps, my lord. I have noticed the word.
Then HCGP takes notice for response number 1 and 2. Learned counsel, Shri S.K. Acharya, who is present before the court, undertakes to file wakalat for response number
4.
for response number 4. R3 is a temple.
Allah.
R3 is temple. R5 you learned counsel would also submit that response number 5 died in the year 2019 on 15/3/2019. Stop. Learned counsel for the petitioner is directed to furnish copies of the petition along with annexures on the learned AGA as well as learned counsel for response number 4. So, steps are also required to be taken in respect of response number 5. So, yes.
In the meantime, the records may also be called for, my lord, records. So, because there are divergent findings, my lord, by the.
Let us see. Yes.
Thank you.
Your lordships, I appear for the petitioners.
Yes.
Appear for the petitioners, your lordships.
Yes.
This is a case regarding the representation given by the petitioners. There are 123, 156 petitioners, your lordships. A land bearing survey number 64 of 4 acres, measuring 4 acres, was identified for issuing Hakkupatra under Ashraya scheme. The petitioners being the localites of Doddabhadrakallu village, Chennaikanapalya and Tippenhalli, they are not considered for the scheme, your lordships. The petitioners being the localites of the Doddabhadrakallu village, they are not being considered for the Ashraya scheme. Rights issues. So I have produced the petitioners are the localites of the Doddabhadrakallu, Chennaikanapalya and Tippenhalli. I have produced their the copies of their Aadhaar cards to show that they are the localites. But in spite of them, with the hand in glove with some other persons, they are considering the applications of the outsiders of the villages. Doddabhadrakallu village.
How is it a land revenue matter? You are only concerned with the allotment sought to be made by the BBMP.
No, it was transferred. The DC has passed orders.
It is transferred to BBMP. BBMP is the authority who is making the allotment. How is it a land revenue matter?
No, only the notification was
not a land revenue matter. There is nothing pertaining to the land revenue, a land revenue act or the rules.
No, the original is
So please,
landlord to speak.
Get it reclassified and go before the bench having roster.
Only direction to the representation, your lords. Only direct to consider it. Only
Allah,
to the
adikene.
direction.
This has got nothing to do with the provisions of the act or the rules. Probably
do
you'll have
consider
to
the lords.
file it as BBMP. BBMP separate agidiyalla classification. LB BBMP.
Yes, your lords.
Office is directed to reclassify this matter as LB BBMP and place it before the bench having roster.
A date may be given, your lordships.
No,
Much.
For the petitioners. But the grandmother of the petitioner named Venkatamma, she filed form number 7 application seeking occupancy under the land before the land tribunal. That she is the tenant under the land law. Lords, during the pendency of that application, my lords, it was noticed by the land tribunal that this land is originally a service land and there is no regrant under the provisions in favor of the land law. Therefore, pending regrant in favor of the landlord, this application cannot be considered. The matter was adjourned same day. This is Annexure C order. Your lordship will get that at page 35 minutes. 1975 order. Land is service enough whose regrant is not yet decided. Case adjourned same day. This is the last order. Thereafter, my lords, after several years, another son of Venkatamma, he files that named Ramchandra, who is the 11th respondent herein. He files form number 7A application. After several rounds of litigation, the matter reaches up to division bench of this honorable court. The division bench of this honorable court says, when form number 7 application itself is not decided, finally, the question of considering 7A application will not arise. Therefore, it dismisses the application and says that 7 application is to be considered. Even brothers of Ramchandra can join in 7 application. Thereafter, my lords, in 2018, this impugned order is passed. In 2018, once again, the tribunal, which is at Annexure A, now, my lords, in the meanwhile, your lordship may kindly take page 20 minutes for me. Unnumbered second paragraph. In this paragraph, your lordship will notice that this land was regranted in favor of the original landowner. Page 20, not internal page 4 of the impugned order. Last, Sadari Adeshadanತೆ G.V. Subbrao bin ವಾಸುದೇವರವರ ಹೆಸರಿಗೆ MR ರಂತೆ ಮೇಲ್ಕಂಡ ಜಮೀನು ಖಾತೆಯಾಗಿರುತ್ತದೆ. This regrant is ordered.
Where did you read?
Para 20. I'll read the entire paragraph. Page 20, unnumbered para. ಚಿಕ್ಕಬಳ್ಳಾಪುರ ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಗಂಗಮ್ಮನ ಮಿದ್ದೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 30ರಲ್ಲಿನ 2 ಎಕರೆ 34 ಗುಂಟೆ ಜಮೀನಿನ ಶಾನ್ಭೋಗ್ ಸರ್ವಿಸ್ ಇನಾಮ್ ಜಮೀನುಗಳು ಅರ್ಜಿದಾರರಾದ G.V. ಸುಬ್ಬರಾವ್ ಮತ್ತು ಪ್ರತಿವಾದಿಗಳು ಶ್ರೀಮತಿ ರುಕ್ಮಿಣಿ ಅವರ ವಾರಸುದಾರರ ಮಧ್ಯೆ ಇರತಕ್ಕ ರೈವಲ್ ಕ್ಲೇಮ್ ಬಗ್ಗೆ ಹೊಸದಾಗಿ ವಿಚಾರಣೆ ಮಾಡಿ ಕಾನೂನು ಅಡಿಯಲ್ಲಿ 6 ತಿಂಗಳ ಒಳಗಾಗಿ ಆದೇಶ ಮಾಡಲು ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಆದೇಶಿಸುವಂತೆ ಪ್ರಕರಣ ವಿಚಾರಣೆ ತೆಗೆದುಕೊಂಡು ಸೋನ್ಸೋ ದಿನಾಂಕ 9/7/98ರಂತೆ ದಿನಾಂಕ 18/7/98ರಂದು 1961 ಕರ್ನಾಟಕ ಅನುಮತಿ ಹುದ್ದೆಗಳ ರದ್ದಿಯಾಯಿಸಿ ಅಧಿನಿಯಮದ ವಿಧಿ 4/3 ಅನ್ವಯ ಸರ್ಕಾರಕ್ಕೆ ದಿನಾಂಕ 1/2/1963ರಂದು ನಿಹಿತವಾಗಿದ್ದು ಗಂಗಮ್ಮನ ಮಿದ್ದೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 30ರ 2 ಎಕರೆ 35 ಪೈಕಿ 1 ಗುಂಟೆ ಖರಾಬ್ ಜಾತಾ ಉಳಿಕೆ 2 ಎಕರೆ 34 ಗುಂಟೆ ಜಮೀನನ್ನು ಅರ್ಜಿದಾರರು G.V. ಸುಬ್ರಾವ್ ಮಾಜಿ ಬರ್ವಾರ್ದ ಶಾನ್ಭೋಗ್ ಮಸ್ಟೂರ್ ವಿಕ್ರರ್ ಅವರಿಗೆ ತಹಸೀಲ್ದಾರ್ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಅವರು ಮಂಜೂರು ಮಾಡಿ ಆದೇಶ ಹೊರಡಿಸುತ್ತಾರೆ. ಸದರಿ ಆದೇಶದಂತೆ. Therefore, there is a regrant. Now that condition which was there in the original 1975, that is. In spite of this, at page 25 minutes. It notices 1975 order and ultimately dismisses the application, saying that the application is dismissed in 1975 at page 29. Now what has happened, my lords?
this Ramachandra also had filed writ petition challenging this order. They have entered into agreement with the original landowners. The agreement is at annexure K. This all has transpired behind my back. I was not aware of this order at all. Recently, when they came to develop the subject property, my lords, I came to know of this order. $75 ಗೇಣಿ ಅರ್ಜಿ ವಜಾ ಆಗಿರುತ್ತದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ವಜಾ ಆಗಿಲ್ಲ, ಅರ್ಜೆಂಟ್ ಸೈನ್ ಆಗಿದೆ. That is also observed by the division bench.
But what about 7A application?
7A application, my lords, became redundant because when 7 application is pending, the question of 7A application could not have been considered. That is the observation.
So it was not considered on merits?
It could not have been considered on merits. That is the observation of the division bench.
No, but here there is a finding that there was an order passed on 39/2005 in paragraph number 2.
Please, my lord. That was again set aside in writ petition. That was again set aside in writ petition. In WP number 17490 of 2011.
Yes. Anyway, we'll have to reconsider. They will have to reconsider. Learned HCGP takes notice for response number 1 to 3. Issue notice to all the other respondents.
Private respondents may be restrained from changing the nature of the property. They are private respondents. Now they have entered into negotiations with among themselves. The landlord as well as one of the applicant who was my paternal uncle. Now they have entered into registered agreement of sale and they are developing the property, changing the nature of the property. I have produced the registered agreement also, my lords, which is at page 87. ಸುಬ್ರಹ್ಮಣ್ಯ ಅವರು ವಾಸದಾರರು ರಾಮಚಂದ್ರನ್ ಮತ್ತೆ ಅವ್ರ ಮಕ್ಕಳ ಜೊತೆಗೆ. Therefore, private respondents may be restrained from changing the nature of the property. Annexure K, page 87. Please, my lords, but
ಏನೇನಾಗಿದೆ ಯಾರು
ಇದು ಇವಾಗಲೂ ವೇಕೆಂಟ್ ಇದೆ. They are trying to change the nature of the property. Status quo.
Petitioner is directed to serve a copy of the petition on the learned HCGP.
Request for an order. Status
Parties are directed to maintain status quo in respect of the possession and nature of the land as on today, till the next date of hearing. Yes.
Petition made a petition in form of 53, seeking grant of land. But as per the annexure G and F, one document of the department shows he is in possession and cultivation of the said land. Committee giving the reason he is not in a possession cultivation rejected the application. The challenge will be provided the AC. AC also same on the ground of same he is not possession cultivation rejected. And once again presented before the DC. DC though he discussed each and everything he is to reject. Para 7 of the page 69. The deputy commissioner has discussed permitted to para 7. DC order in page 69. ಅಲ್ಲದೆ ಅರ್ಜಿದಾರರು ಸರ್ವೆ ನಂಬರ್ 39 ನಲ್ಲಿ ಸಾಗುವಳಿ ಮಾಡುತ್ತಿರುವ ಬಗ್ಗೆ ಸಂಬಂಧಪಟ್ಟ ಗ್ರಾಮ ಲೆಕ್ಕಿಗರು ರಾಜ ಸ್ವನಿರೀಕ್ಷಕರು ಹಾಜರು ಮಾಡಿರುವ ಬಗ್ಗೆ ಕಡತದಲ್ಲಿ ದಿನಾಂಕ 9/2/2053 ದಾಖಲಾತಿಗಳು ಲಭ್ಯವಿದ್ದರೂ ಅನುಭವದಂತೆ ನಕ್ಷೆ ಹಾಗೂ ಇತರ ದಾಖಲಾತಿಗಳು ಇದ್ದರೂ ಅದು ಕೇವಲ 5 ವರ್ಷ. Since 1953 they are in father time they are in possession cultivation. And next melod 65 ಸಾಲಿನ ನಂತರ ದಿನಗಳಲ್ಲಿ ವಿವಾದ ಜಮೀನು ಸಾಗುವಳಿ ಮಾಡಿರುವಂತ ದಾಖಲಾತಿಗಳು ಹಾಜರುಪಡಿಸುವ ರೀಸೆಂಟ್ ಡಾಕ್ಯುಮೆಂಟ್ has not produced ಅಂತ ಹೇಳ್ತಾರೆ. ಅಂದ್ರೆ annexure F and G ಮೇಲೆ annexure F is a and annexure G is a major. It's a mentioned Miller, surrender typed copy Miller by page 45. Fourth column, 7 number mentioned Miller, 7 number 39 ಅಲ್ಲಿ ಒಂದೊಂದು 6 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣ ಇದು ಹಾನಿ ಅಂತ ಖಾತೆಯಾಗಿದೆ. ಉಳಿಕೆ 8 ಪ್ರದೇಶದಲ್ಲಿ ಹಾಲಿ ಕೆ ರಾವ್ and ಕೆ ಭೀಮೇಗೌಡ ಇತರೆಯವರು ಸಾಗುವಳಿ ಮಾಡುತ್ತಿರುವುದಕ್ಕೆ ಕೆಲಸ. And also Maharashtra ಸಾಗುವಳಿ ಮಾಡ್ತಾ ಇರೋದ್ರಿಂದ when the officers come.
Some other persons.
ಕೆ ರಾವ್ and ಭೀಮೇಗೌಡ ಇತರೆ.
That is some other persons.
Including Demerger is in possession and possession.
Demerger is the petitioner.
Petition is a Demerger.
Where did you read that?
What is annexure F 44 Miller, typed copy is in 45. Fourth column. Typed copy. Survey number 39ರಲ್ಲಿ 11 6 ಗಮಟೆ ವಿಸ್ತೀರ್ಣ ಇದ್ದು ಹಾನಿ ಅಂತ ಖಾತೆಯಾಗಿದ್ದು. ಉಳಿಕೆ 8 ಪ್ರದೇಶದಲ್ಲಿ ಹಾಲಿ ಕೆ ರಾವ್ ಕೆ ಭೀಮೇಗೌಡ ಇತರೆಯರು ಸಾಗುವಳಿ ಮಾಡುತ್ತಿರುವುದಾಗಿ ಕೆಲಸಕ್ಕೆ ಅಡ್ಡಿಪಡಿಸಿದರು. ಕೆ ಭೀಮೇಗೌಡ also is in possession cultivation and therefore is disturbed the rank of sketch from the revenue department. Next annexure G Miller.
That is your statement.
Before the infant of the officers of the revenue. And Miller, annexure G is drawn by the revenue officers. The major in which Miller.
AGA. Take notice for all the respondents. Annexure K. Second page, Annexure K is an order dated 6/8/2018.
This document. This document has produced to shows Millard. Petition made application survey number 13. Initially, Millard, some of the officers stated that this land in survey number 39 has been allotted to Kittur Rani Channam. But Millard, that the survey, land in survey number 39 has not been allotted to Kittur Rani Channam. The land allotted in survey number 95. Therefore, Millard, land in survey number 39 is no more required for the purpose of construction of building of the Kittur Rani Channam. Therefore, Millard, this document has been produced. And in which Millard petition is position cultivation is not required for this purpose. Because the Kittur Rani Channam College has been allotted land already in survey number 95, measuring 8 acre 25. Therefore, to show that this is 95 is different. 39.
See, you are pointing out to annexure H, which is dated 3/5/2017. And there they say there is no form number 53 pending consideration. Adadmele assistant commissioner passes an order on the application. Annexure K, dated 6/8/2018. When was the application rejected by the committee?
17/9/2016.
2016.
2016.
So ಅಲ್ಲಿ ಸರಿ ಇದೆ ಅವರು ಹೇಳಿರೋ ಸ್ಟೇಟ್ಮೆಂಟ್ 2016 ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಡಿಸ್ಮಿಸ್ ಆಗೋಗಿದೆ. So as on the date when the deputy commissioner considered the request for reserving this land for Kittur Rani Channamma Vasati Shale, there was no application pending. Your application was not pending consideration.
Land granting in survey number say 95 million. My survey number is 39 million. This land in survey number 95. And this document has produced Milan. Initially, some of officers stated land of the survey number 39 has been allotted to the Kittur Rani Channamma Milan. But this document has been produced before the court to say the land allotted to the Kittur Rani Channamma is survey number 39, not in 95, not in 39. Therefore, land in which I am in possession is not required for the purpose of the Kittur Rani Channamma.
Learned AGA takes notice for all the respondents. Learned counsel for petitioner is directed to serve a copy of the petition on the learned AGA. Next para. Since it is the apprehension of the petitioner that consequent to the last order passed by the deputy commissioner on 20/12/2021 at annexure M, the respondent authorities are trying to evict the petitioner from the land in question. The respondent authorities are directed not to evict the petitioner from the land in question, until further orders. That is land in question. That is ಎಷ್ಟು ಕೇಳಿದ್ರಿ ನೀವು?
Survey number 39.
ಎಷ್ಟು ಕೇಳಿದ್ದು land?
3 acres.
It is 3 acres of land in survey number 39 of Kadiri Devarahalli, Gauribidnur Taluk. Yes. Yes.
Out of a total extent of 22 acres, 26 acres. That's 4 acres and 30 guntas was given to a sugar mill. The remaining 22 acres was given to 11 landless persons at the rate of 2 acres per person in the year 1949-1950. Thus, we have purchased 14 acres, 20 guntas out of this 22 acres. Year 1963, revenue records are mutated in our favor. The office of the respondent number 5 My lord, generated a communication. May I request this court to kindly take annexure D, page 70, my lord, 70. I read this letter, my lord, it's very critical. With reference to the above,
Registrar, Principal District and Session Judge.
Chikbalapur. The office of the Principal District and Session Chikbalapur writes a letter to the Deputy Commissioner. With reference to the above subject, I write to inform you that on 7/12/2015, I held a meeting with the Assistant Commissioner Chikbalapur and Tahsildar Gauri Vidnu regarding identification of suitable land for construction of the court building. Survey number 59/12 of Alkapura Village, Tondebavi Hobli, Gauri Vidnu Taluk. On my visit, I found that the said land is a barren land, not fit for cultivation, nor it is cultivated. The Tahsildar has informed me that the said land is a granted land. It appears nobody is cultivating that land. Even as on today, land is found to be more suitable for construction of a court complex and office quarters. Since the violation of grant is apparent on the face of the record, therefore it is requested, you are requested to allot 10 acres of land in the said survey number immediately for the said purpose, by resuming the land back to the government. Resumption of land which has already been sold would not arise. Now the Assistant Commissioner, after the land has been sold, resumes the land, my lords, pursuant to this letter. No inquiry, I mean, Tahsildar does it, no inquiry, no proceedings. I, my lords, file an appeal. My lords, the Assistant Commissioner goes a step ahead. He says, not only 10 acres for the court, I will give it for PWD department also. The scope of the appeal is only whether the order of resumption should be either confirmed or it should be set aside. Therefore, now, my lords, I am before this court. I have not been heard. This order at annexure D, which is passed by the assistant, the Tahsildar, the 2-page order, he says, I have inquired the localites for the last 50 years, this land is not under cultivation. Therefore, I am resuming these lands. I have purchased these lands in 1963. Lands are standing in my name. He says even the purchaser has not cultivated the lands. There is a question of resumption of lands, my lords, after the sale has taken place. Original grant is in 1949-50, not disputed. That, my lords, would not arise. I am under instructions to state, my lord, even for some reason, if the government were to notify it for acquisition and pay us compensation, we are still okay with it. Resuming lands in this manner, my lords, therefore I sought for a stay of annexure team. And the respondent number 5 cannot decide the issue as to whether there is a violation of the terms.
That is only a
Communication.
Aster.
Yes.
That is not an order.
But since he is the beneficiary, I formally had to make him a party. That's all. It was all initiated pursuant to annexure D.
So, not AGA, HCGP. Take notice for
all respondents except respondent number 5.
all respondents except respondent number 5. Issue notice. Issue emergent notice to respondent number 5.
Please.
Learned counsel for petitioner is directed to serve a copy of the petition on the learned HCGP. So, next para. Learned counsel for the petitioner submits that the petitioners are the owners in occupation of 16 acres of land.
14 acres, 20 guntas out of 16 acres.
14 acres and 20 guntas of land in survey number 59 of Tondebavi Hobli, Gauri Bisnur Taluk, Chikbalapur district,
Alkapura village,
having purchased the lands way back in the year 1963-64. So, however, at the instance of the fifth respondent, who made a communication dated 9/12/2015 at annexure B, the Tahsildar initiated proceedings before the assistant commissioner.
He so moto did it. See, gave a report to the assistant commissioner as per annexure C, and then he passed an order by annexure D by himself. Annexure C is only an internal report. He passed an order as per Annexure D of resumption.
However, at the instance of respondent number 5, who made a communication dated 9/12/15, the annexure B, the Tahsildar.
The Tahsildar, Gauribindur Taluk, proceeded to pass the impugned order dated 2/3/2016 at Annexure D. Cancelling the grant made in favor of the original grantee and directed resumption of the lands leased while entering the name of government in the land records. So, Learned Council submits that the original grants were made in the year
1949-50.
1949-50, and the petitioners have purchased the land way back in the year 1963-64. And therefore, it was impermissible for the revenue authorities to have passed an order cancelling the grant only on the ground that the original grantee has not cultivated the land in question. Stop. Apparently, no notice is issued to the petitioners before the impugned order was passed by the Tahsildar. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned order.
Annexure D, E and F.
Impugned orders dated, impugned orders at annexures
D, E and F.
D, E and F, comma till the next date of hearing.
Number 23, Ian J.
Huh?
Matter last week only. There are lots of since partner.
Huh?
Can they seek appointment?
Yes, yes.
Tuesday or Wednesday.
Huh? Sailing with yes, yes. Although the matter was directed to be listed today here on the question raised on the last occasion, nevertheless, Learned Council for the contesting respondents number 1, 3, 5, 6 and 10, 6, 10 to 16. Submits that the Learned Senior Counsel is unable to appear today and therefore seeks for a short accommodation. Stop. Release this matter on 18th of January. Yes.
The afternoon is inconvenient for the senior counsel engaged by us. Kindly have it on 24th.
at the request of the learned counsels on both the sides, release this matter on 18th of January.
18th is, senior counsel is not.
Hmm?
Senior counsel is not available on 18th. Can you have it on 17th?
17th.
Hi. Yes. For appointment of arbitrator. Respondent number 2 was supposed to appoint an arbitrator. They have not done so. Therefore, we should notice, my lords. Notice.
That they objected
Yes,
before the civil court,
Yes, my lords. They filed 2
that the
applications.
suit is not maintainable.
Suit is not maintainable. It has to be
Yes.
referred to the arbitration.
Can be appointed. Yes. Retired High Court judge.
Recovery in a sum of 2.24 crores as on the date of filing the suit. So. We are not interested in apartment villas because purpose will not.
No,
be served.
even before the arbitrator, you can,
Yeah,
there
yes, yes, yes.
is no difficulty. The civil miscellaneous petition is filed under section 11(6) of the Arbitration and Conciliation Act from 1996 to appoint a sole arbitrator to resolve the dispute between the parties in terms of clause 17 of 2 agreements
17 and class 16.
of sale, both dated 11/9/2014, and clause 16 of the construction agreements, 2 construction agreements, both dated 11/9/2014. Stop. Next para. Learned counsels for the respondents fairly submit that the sole arbitrator may be appointed. Stop. Next para. Consequently, this court proceeds to pass the following order. We will appoint Justice Padmaraj. Is comparatively free,
Yes, sir.
and this is a matter that can be decided, and you are saying that still negotiation is going on.
Yes, sir. We have no objection.
Justice Padmaraj. Yes.
It will fix so that we can appear. before.
Illa. There is a particular format
Yes.
in which
We have
the
to-
order is passed. They will they'll have to intimate the arbitrator,
Take under 2
and
months.
he has to do it.
Take under 2 months.
Yes.
Yes.
E. Padmaraj.
Petitioner is the landowner who entered into a joint development agreement. The possession, my lord, having not been delivered, my lord, a notice was issued. Raising, my lord, the concern and my lord.
Any objection? ಏನ್ objection ರೀ? ಅದಲ್ಲ. Here we are only concerned with appointment of a arbitrator. ಮಿಕ್ಕಿದ್ದಲ್ಲ ನೀವು ಅಲ್ಲೇ ಅವ್ರ ಮುಂದೆ ಹೇಳ್ಬೇಕು. At the request of the learned counsel for respondent, release this matter on 18th of January. Sir, if it is a simple straightforward matter.
My lord, actually.
Is it not mentioned in the document? If it is
My-
mentioned as
my-
Mysore, then it should be Mysore.
That's not an issue. My main issue is the entire transaction took place in Bangalore.
Huh?
Entire transaction.
Angala, sir, if the document specifies so,
Yeah.
then how can you argue to the contrary?
It's okay. If the court, your honorable court orders, we are ready for Mysore. Mysore's arbitration center is not fully working at the moment. Hence, if the court orders, we consider that also. Page 20. Page 20 is there, my lord. But due to, since the facilities are not available, and as also the entire business transaction takes place at Bangalore. So the sitting at arbitration shall be at Mysore. Page 20, para 10, my lord.
The disputes or differences between the parties within the agreement should be resolved with the sole arbitrator who will be appointed under mutual agreement. The arbitrator shall be at night. In case of any legal disputes or litigation, the jurisdictional court shall be Mysore court only.
Not an issue.
But if they are agreeable, then we can do it in Bangalore. You please consider because.
I will again speak with you, my lord. Right now it is not agreeable. I'll again one stick and submit.
Next week, my lord. Because this is a pending matter, more than 1.5 crores is lying with the respondent. Is playing this kind of tricks though. Because why we are insisting Bangalore means the entire transaction with the state-owned company, maybe any clarifications, we may cheat to the direction of whoever purchaser, it's a government of Karnataka undertaking. In that context, we are prevailing upon this.
Karnataka soaps and detergent.
Yes, my lord. There have more than 35 crores transaction takes place.
Learned counsel for the respondent has drawn the attention of this court to the arbitration clause contained in the goods agreement dated 24/8/2020 and submits that in terms of the said clause, the place of arbitration is agreed to be at Mysore. Stop. However, the petitioner is seeking that the matter may be referred to the arbitration center at Bangalore. Stop. This is the only point of contention between the two parties. Full stop. Nevertheless, learned counsel for the respondent seeks for a short accommodation to once again consult the respondent and make his submissions. Release this matter on 18th of January. 25th of January.
Reply for petitioner. Notice is served to respondent. This panel advocate may be permitted to serve the
BMTC.
Yes.
Learned counsel for the petitioner is permitted to serve a copy of the memorandum of civil miscellaneous petition along with annexures on learned counsel Sri B.L. Sanjeev, who appears for the respondent BMTC. So, release this matter on 18th of January. Huh? 1/2/2023.
Yes, application under 10/7 of arbitration.
Office objection.
Claim petition was not filed in time, and it was closed for time being. Since the petition is before this honorable court by of this taking liberty to file a fresh claim.
No. What is the objection? Office objection raised.
Office objection, notice not served to the rest. Copies are not served to the rest.
Sir, madbekalla.
Will serve.
Please serve a copy on the other side. A week's time is granted. At the request of learned counsel for petitioner to serve a copy of IA number 1 of 2023 on learned counsel for the respondent.
Permitted a week's time to find the acknowledgement for having served. Respondent.
Hand summons, sir. You have taken out hand summons. Release this matter on 18th of January 2023, at the request of learned counsel for petitioner. Yes. Inquiry ಮಾಡ್ತೀರಾ? 11 ಆಫೀಸ್ objection ಇದೆ. Pass over. On 4/1/2023, the following order was passed. Matter is called out. There is no representation for the petitioner. Consequently, the writ petition, the civil miscellaneous petition stands dismissed. Same order. 4/1/2023.
Appearing for the petitioner. Mr. Manish Jha will also be appearing for the petitioner through BC.
I'm appearing your lordship on behalf of the petitioner. This is section 11 application. Notice was issued on 6th of January 2022. And we have also filed affidavit of service. And they have been served not only through email, but also through courier. But they are not appearing. They did not even appear before the district court where we had filed section 9 petition.
Yes.
So your lordship may see the prayer, the arbitration
No,
clause.
let us see your affidavit. You are not permitted to take out hand summons or to serve otherwise. What was directed was issue notice to the respondent, and that notice has returned with a postal shara that no such person.
But your lordship, if
and what is the affidavit that you have filed now?
The affidavit is, if your lordship may see para 4 of my affidavit, I have stated that on January 7th, I issued an email and served copy of the petition on January 9th.
That was not permitted by this court.
Now, your lordship, he is not appearing. Even before the district court, he did not appear. So we had to take substituted services. We are facing this difficulty because he is not coming forward. There is a Section 9 petition filed. Interim order was passed for deposit of the entire money, but he has not complied with that order also. And if your lordship, you see page 7, the company master data of the company, email ID is of Manav Chaudhary. On this address, we have serviced.
Therefore, you had to take the permission of this court,
your lordship,
by filing necessary application to serve the respondent through email.
We'll do that, your lordship.
Please do that.
We will do that.
And time is granted at the request of the learned counsel for petitioner to file necessary application seeking substituted service on the respondent through email. Yes.
Are you obliged to him?
Right.
Number 35, Ms. Narayan.
Furnishing of petition copy. Chamber build up otherwise what is this? Furnishing of petition copy along with annexures andre order ಇದೆ Supreme Court. Matter is called out. There is no representation for the petitioner. Release this matter on 18th of January. A week's time is granted at the request of learned counsel for petitioner to take steps in respect of respond number R3B.
Honor, the amendment of cost title is carried out and the same is filed before the counter ruling.
When?
Today, Your Honor.
Learned counsel for petitioner submits that the amended cost title has been filed in the office this morning. Office to verify. Yes.
But I have filed an application for amendment. Also for appointment of commissioner.
Yes. Huh? Well, last time I had directed.
Muda, I have, your lordship said direct. I have served the copy on Vivek Muda.
What the extent of land is what is acquired for the benefit of petitioners is only 4 acres 30 gunta.
Allah, we are on the application filed for amendment. Amendment and appointment of commissioner.
6 acres, 17 meters is the total extent. 4 acres, 30 meters is what is notified in favor of the petitioner society and that will reflect revenue on 4 acres, 30 meters. It was only 4 acres, 30 meters, by mistake, article reflected 6 acres, 70 meters in entirety in favor of the petitioner society. I made an application for rectification. What is notified is only 4 acres, 30 meters, remaining extent should revert back to me. The other initiated and rightly the assistant minister has restored the article in my name. They say, in spite of 4 acres, 30 meters, it is notified, I am in position of.
You are representing Muda.
I am no.
Private
party. 5A to 5B. I am the land.
Ah.
I made an application to restore my name in the RTC Act on the condition that though what is required in favor of the petitioner society is only 4 acres, 30 meters, inadvertently, the entire extent of 60 acres, 30 meters is reflected in their name. Kindly restore the RTC, the additional extent.
Why is Muda a party here?
But Muda has developed the entire layout, including the 6 acres, to the entire extent of 6 acres. It has executed sale deed in favor of the allottees, members of the society, way back in the year 1990-91. The entire layout is developed, houses have come up. The revenue entries for the entire 6 acres was entered in the year 1988. And it continued up to the year 2007. Lords, the fifth respondent makes an application in 2007 after about 19 to 20 years, asking for restoration on the ground that the extent acquired was 4 acres 30 guntas, 1 acre 27 guntas were not acquired. And on the basis of his application, Lords, the revenue entries were restored for that extent of 1 acre 27 guntas. But then, Lords, in this duration of 20 years, the development has taken place. Muda has executed sale deed in favor of allottees about
So
19.
you are in actual possession. The individual site owners are
Individual site owners are in possession who are the members of my society, Lords. And houses have come up. I have produced the photographs, Lords.
So it is not
It is actually as on today falling in Siddhartha layout of Mysore, Lords. And all these allottees were never heard before the assistant commissioner or before the deputy commissioner.
Yes.
And therefore, I have filed an application, Lords, now producing documents where the sale deeds are executed by Muda in favor of these members. And also I have produced photographs as additional documents to show the present status of the layout. And I have sought for Lords appointment of commissioner.
And what is the efficacy of the land revenue records now, since the land is within the limits of the Mysore city corporation?
It's no more a revenue land also.
What efficacy can be had to the revenue entries, sir? ನಿಮ್ಮ ಹೆಸರಿಗೆ ಮಾಡಿಕೊಟ್ರು ಏನ್ ಪ್ರಯೋಜನ ಅಂತ? It's a layout formed by the Muda, sir. That is why they have implemented them as a respondent number 4. So therefore, at that point of time, if you have not taken action to stop them from forming the layout, what is the use of now going and asking for entry in the land records? Correct. What action have you taken? It is of no consequence. That is why I am saying it's of no consequence, only seeking change in the entries in the land records. Yenu prayana illa adrinda.
If I am able to demonstrate that this 17 is still vacant, or third party interest is not created in favor of the allotted from Muda, still my lords, this 1 acre country Muda is vacant. As per the interest of this is vacant. If at all it is declared, if the revenue entries are restored to my name, at least I will be in a position to fight against Muda, my lords.
Why only revenue entries are restored in your favor?
Say that what was notified in favor of the petition society got restored in my name.
For that purpose, you did not wait for an order to be passed by the revenue authority, sir.
2007 itself.
88 Lords, the layout is formed.
The Lordship will kindly see the order of the deputy commissioner.
If
So really now before this honorable, now at this created stage.
what is the amendment that you are seeking now?
That's all that I'm seeking for is to produce the sale deeds in respect of those allottees. And also, my lords, I have produced the photographs to show the present status of the layout.
It can be allowed. It can be allowed. What is this appointment of commissioner?
Let's to
He exercise
report,
not in.
of course, I understand, lords, but
Order on IA number 2 of 2022.
it's only as a measure of precaution if they dispute the status of the land. That's all I have produced.
All that question will not arise here at all. If there is any dispute that would arise in respect of the physical possession, parties have to approach the competent civil court, not even before the revenue authority.
It is. Even for that, my lords, he approaches the assistant commissioner and files a letter after 20 years when the entries are reported.
You have filed objections. Let us see your objections.
Claim of the petitioner is what corresponding to that effort to be a land in various other number of articles in favor of the petitioner for formation of representative and also found a waiver on behalf of the petitioner. It is appealed to note that all of the above the calculation did not include the land of deceased. Majorly 1 acre 27 acres of land. Originally considered of 6 acres 17 acres of land. Out of the only that an extent of 1 acre 25 acres is not in rate of the total of population and remaining is the one of the top rates in Karnataka. The erosion is showed in name of PAPB in the entire extent of 6 acres 17 acres. Therefore, the state Karnataka during this election and rightly made an application for correction of RTC with respect to column number 9 to an extent of 1 acre 27 acres of land is column number 57 by 1. The perusal of this application makes it clear that only 4 acres 15 acres based on this application, the board respondent, that is good ask, has given an endorsement dated 7/7/2007. Here, that an extent of
Have you stated in your memorandum of petition that the layout has been formed even in respect of the other extent?
Yes,
and you are in possession?
I have stated that.
Please point out.
Para 9, your lordships may kindly.
Yes.
The third respondent white letter dated so 11/8/2008 indicates that though only an extent of 4 acre 30 guntas in survey number 57/1 Satgali village is acquired, RTC entries show the name of CITB to an extent of 6 acres 17 guntas Mysore. An extent of 1 acre 27 guntas is erroneously included while forming the layout for petitioner. As per the layout plan sanctioned by the MUDA, since then several houses have come up. This process is initiated on the basis of some persons claiming to be Chikkanna having surfaced after 2 decades of formation of the layout, seeking entry of his name in the RTC, allegedly claiming to be in possession of 1 acre 27 guntas. Accordingly, third respondent requests third respondent hearing to accord permission or pass suitable orders to initiate proceedings with respect to effect of so and so. Notice the second respondent on the basis of the letter of dated so and so of third respondent issued an official communication to the petitioner herein wide dated 18/9/2008 directing them to show cause and furnished failing which suitable proceedings would follow. Petitioner gives a reply to the second respondent giving explanation to show cause notice.
Please come to paragraph 14.
14. So the second respondent ought to have summoned MUDA and given an opportunity to give an explanation in the matter, as they are the one who have formed the layout for petitioner, which according to the third respondent erroneously included 57/1 measuring 1 acre 27 guntas in the layout found by the MUDA and sites allotted, houses constructed. The second respondent ought not to have proceeded on some letter issued by an officer of MUDA, even assuming the layout includes 1 acre 27 guntas of survey number 57/1. The serious point for consideration whether such correction rectification proceedings be initiated after a gap of 20 years, allowing the petitioner and his members to be in peaceful possession.
So therefore they have stated that they have formed the layout and it has been allotted, but you have not chosen to meet those averments in your objections.
In support of this notes, I am now furnishing these documents. He claims that he is the cousin brother of respondent number 5 and 6.
Order on IA number 2 of 2022. This application is filed at the hands of the petitioner society to amend the memorandum of petition. Stop. Learned counsel submits that the petitioner has stated in the memorandum of petition that the fourth respondent, Mysore Urban Development Authority, formed a layout to an extent of
in survey number 57,
total extent in
total extent of 50 acres. Petitioners
to an extent of more than 50 acres, including 6 acres and 17 guntas of land in survey number 57/1. But our idರಲ್ಲಿ ಆತರ ಹೇಳಿದ್ದಾರೆ. No. That is what has been stated here, so I am repeating that.
Proposal for the petitioner submit that the petitioner has stated in the memorandum of petition that respondent number 4, Mysore MUDA, formed a layout to an extent of more than 50 acres, including 6 acres and 70 guntas lot in survey number 57/1 of
ಯಾವ ವಿಲೇಜ್ ಅದು? ಸಾತ್ಗಳ್ಳಿ ವಿಲೇಜ್, ಕಸ್ಬಾ ಹೋಬಳಿ, ಮೈಸೂರು ತಾಲೂಕು. Stop. It is also stated that the society has allotted the individual sites carved out of the said layout, including 6 acres and 17 guntas of land in survey number 57/1. So, in order to support the said contention, certain amendment is sought to be brought to the memorandum of petition, along with documents of title, that is sale deeds executed in favor of the members of the society. Full stop. Learned counsel for the contesting respondents submit that they will have no objection to allow the amendment and to permit the petitioner to produce the copies of the sale deeds
and layout plan.
And
Layout plan.
the layout plan. Stop. Next paragraph. Accordingly, IA number 2 of 2022 is allowed. The petitioner is permitted to amend the cost title and furnish amended cost title. Furnish the amended memorandum of petition and to furnish the amended memorandum of petition within a period of 1 week from today. However, next para, the contesting respondents are permitted to file additional statement of objections in view of the amendment allowed to the memorandum of petition. Yes. IA number 3 of 2022 will be considered along with the main matter.
Next matter, number 39. Continue, Allah, silent.
Court officer.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸಾಹೇಬ್ರೆ, ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸಾಹೇಬ್ರೆ, ಎಷ್ಟಾಯ್ತು ಸರ್ ಸೀರಿಯಲ್ ನಂಬರು?
ಹೇಳಿ ಸರ್, ಏನ್ ಹೇಳಿ
ಸಾಹೇಬ್ರೆ, ಎಷ್ಟಾಯ್ತು ಸರ್ ಸೀರಿಯಲ್ ನಂಬರು?
ಕೋರ್ಟ್ ಆಫೀಸರ್, ಹಲೋ ಹಲೋ ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಬರ್ತಾ ಇಲ್ಲ ಸರ್ ಡಿಸ್ಪ್ಲೇ ಅಲ್ಲಿ ನಿಮ್ಗೆ.
ಹಲೋ ಸರ್, ಕೋರ್ಟ್ ಆಫೀಸರ್, ದಿ ಸೀರಿಯಲ್ ನಂಬರ್ 48 ಅರ್ಜೆಂಟ್ ಆಗಿದೆ ನೋಡಿ.
ಇಲ್ಲ ಇಲ್ಲ ಅರ್ಜೆಂಟ್ ಆಗಿಲ್ಲ ಸರ್, 38 ವರ್ಗೂ ಆಗಿರೋದು ಅಷ್ಟೇ.
ಅಲ್ಲ 48
ಆಗಿಲ್ಲ ಸರ್,
48
ಆಗಿಲ್ಲ. ಥ್ಯಾಂಕ್ ಯು.
ಓಕೆ ಓಕೆ
ಸಾಹೇಬ್ರೆ, ಡಿಸ್ಪ್ಲೇ ಅಲ್ಲಿ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ ಎಷ್ಟು ಸೀರಿಯಲ್ ನಂಬರ್ ಆಗಿದೆ ಅಂತ ದಯಮಾಡಿ ಹೇಳಿ ಸಾಹೇಬ್ರೆ.
38 ಸರ್.
38. ಥ್ಯಾಂಕ್ ಯು ಸೋ ಮಚ್. ಥ್ಯಾಂಕ್ ಯು.
Full stop. Then council submits that in view of the said observation of the honorable court, the application has been filed. Full stop. Next para. Accordingly, the application is allowed. The proposed respondents are permitted to be brought on record as party respondents
4 and 5.
number 4 and 5. Learned counsel for the petitioner shall carry out the amendment to the cost title and furnish amended cost title within a period of 1 week from today. Full stop. Next para. Issue notice to the newly implemented respondents number 4 and 5. Please.
This matter is similar to your lordship yesterday, WP number 148 for 2023, to appear before the deputy commissioner on 20th 1, 2023, and pass orders. This is also included the petitioners.
Office objection is overruled. Yen madri adralli?
20th 1, 2023 at 11 a.m. The petitioner is to appear before the respondent number 2 deputy commissioner, and he examined the title deeds.
Where is that order?
That is yesterday order, lordship passed the order to appear, and 31 before 31st they have to pass the order in 148 of 2020. That's the 2020. Uploaded. Lordship was given to all the persons to appear. Here is the given the endorsement. You have taken the compensation. That you are
survey number 33.
33. Here is the case. This also the land is not included in the 4161 notification. No award was passed. They said
Learned AG takes notice for all the respondents. Huh? Same order on note convert.
148.
Day before yesterday, vacating the application has been.
Huh?
Objections to that.
Awaiting service of notice on response number 7.
5 notes is no more law. Not the contesting respondent. The applicating final respondent not the soliciting respondent. That is the I find and the application not for the
Before yesterday, copy has been file my objections to that. Other documents additional documents
and it is their own document. I not for any other document.
It is not my own document. 2 of the documents may not be dispute that. The 1908 lease deed and
I am not they have submitted before that the second respondent has 2 more than this opportunity. That is absolutely false. He has not taken up anything more opportunity. But they dispute with regard to the intent and survey is pending before the second respondent. But I also initiated intention to against the petitioner here. Injunction is granted against him. And not the survey proceedings, not the survey authority conducted joint survey in presence of both the parties. And not he has not disputed the first survey. Wherein not the first survey he has not verified as to what extent I am there. What the petitioner is there. Not for the first survey, I find the clarification. Conduct the second survey which is in the presence of the both the parties. And ascertain as to what extent we are staying this premises. But it is not a sumoto proceedings. Here, this only case is what this sumoto proceedings is initiated after lapse of 3 years is not permissible. And I agree. It is not a sumoto proceedings. Application was filed. He appeared before the authority. First survey was conducted. They are not objective to the survey. And in the first survey, there is no extent as to what extent I am there. But therefore, not second survey is also conducted, but all modification was done. But it was about to pass orders, but at this stage they have come up before the court and got it stated. Let the survey outcome of the survey come out. And so we will come to know
1975.
Matter is pending before the second respondent.
The trust property, 1930 is when, my lord, the property, my lord, is granted to the trust. My lord, from past 70, 80 years, my lord, there is a component trust is there, my lord. Now, my lord, because it has come within the Bangalore premises and certain portion is vacant, my lord, all of them, my lord, are claiming ownership of the property on flimsy ground, my lord. Kindly see, my lord, document annexure F, page 50.
You have put up a compound wall.
Yes, my lord. Compound wall is there, my lord. Schools are there, my lord. School and even college is being run, my lord, in that premises. I will place all those documents on record. My lord, kindly see annexure F, page 50.
Where is what is that report?
My lord,
Where is that report?
my lord, annexure, my lord, with respect to this, my lord, the first initial survey, my lord, annexure B, B1, my lord, page 29 and 30. 1975 is the first survey, my lord. B1, my lord, page 31. Page 31, my lord. The typed copy, my lord, comes page 33.
Page 31 is a mutation.
Survey, my lord. The first survey as to regarding this property.
Page 31 is mutation extraction.
Yes, my lord. Annexure B, my lord, page 29 is the sketch, my lord. CTS sketch. CTS sketch. It is the first survey where, my lord, CTS number 1094 was assigned to my property.
How can you call it a survey, sir? It is a map.
My lord, in map, my lord, kindly see, my lord, annexure B1.
Annexure B1 is a mutation.
My lord, CTS survey, kindly see page 32, my lord. My lord, the extent of the land is mentioned. 37,736.7 square meters. Srimati Kamalabai Educational Trust. Accepted and confirmed. In respect to
10,280 was the actual portion. It was deciding. But that was modified to 27,000.
There is a record for that, my lord. With respect to the respondent 5 hearing, my lord. Respondent number 5, my lord, initially claimed, my lord, he is the owner of the adjacent land owner. And he claims title, my lord, with respect to an RS Dias. And he has filed, my lord, suit before the trial court that he is claiming that property under the will. That suit itself came to be dismissed, my lord. He has suppressed that.
Now raising a claim that they are in unauthorized occupation of your land.
Yes,
what is the use of asking changes in the land record, sir? Go file a suit before the civil court and get an order, declaration. This is of no consequence. These entries in the land records are of no consequence. These are all lands within the limits of BBMP. No, sir. We will consider. We will consider. Not now, not now. List this matter after service of notice on the unserved respondent. Interim order granted earlier stands extended in the next year again. No. No, sir.
Annexure C is challenged so far as office objections are concerned. But they say, my lord, schedule is not mentioned. And my lord, what is the interest that the petitioner has, my lord, are 2 office objections.
Yes.
Lord, may be permitted to file a memo, my lord. To indicate schedule, here is the first para, here is Lord, survey number 33, Lord, to an extent of 21 guntas, Lord, is mentioned in para 1 of the writ petition. Boundaries are not furnished, my lord. Lord, annexure C, Lord, is what is challenged. Lord, the petitioner is the owner, my lord, with an extent of 21 guntas, is survey number 33. RTC is produced, he got it under a partition. Oh, my lord, there was a PIL where, my lord, all encroachments to Raj Kalve were directed to be removed. That order also I have produced at Annexure B. Now, my lord, please see Annexure C, where, my lord, they have issued this sketch for the first time. Nakshe. And then for the first time, my lord, they are forming a Kalve, my lord, Nala in survey number 33. If my lord sees the earlier sketch, my lord, in 1975, which I have produced at page number 24, Annexure E. My lord, the Nala runs all along. My lord, survey number 34 on the top and all along, my lord, the boundary on the left.
What is this portion marked in the dark?
My lord, that is survey number 33, my lord. That is 33. My lord, it runs all along the boundary in 34. Now the sketch that is produced without notice to me, that is the same sketch, my lord, which my lords will get at Annexure D of the adjoining land. Please see Annexure D page number.
The area measuring 1 acre, 1 gunta. The darkly marked portion is 1 acre, 1 gunta.
1 gunta, my lord. This is 1 acre, 1 gunta in survey number 34. What I am trying to demonstrate is this Nala runs all along, my lord, the boundary between 34 and 33. Now, my lord, if my lord sees Annexure D, my lord, it is more clear. Annexure D, 1 page earlier, my lord. My lord, towards the east, my lord, is survey number 33. Towards the west, my lord, is survey number 34. Adralli Nala hogta irodu clear ಆಗಿ ತೋರಿಸ್ತಾ ಇದ್ದಾರೆ. Now, my lord, they want to form a fresh Nala in survey number 33, which is to, in this map, my lord, this portion, vacant portion, where there is no Nala. It runs all along, my lord, the boundary of 34, the old sketch as well as the new sketch. Now the new Nala that is sought to be made in Annexure.
They are only showing this last portion.
My lord, it is running, my lord, coming down and
last portion alli nimma map ಪ್ರಕಾರ ಇಲ್ಲಿ ಒಳಗಡೆನೇ ಇದೆ.
ಅಲ್ಲ ನಮ್ದು ಕೆಳಗೆ ಬರುತ್ತೆ, ಜಮೀನ್ ಕೆಳಗೆ ಬರುತ್ತೆ ನಮ್ದು.
ಇದಾ?
ಹೌದು.
ಅದರಲ್ಲಿ ಇಲ್ವೇ ಇಲ್ಲ.
ಅದ್ರಲ್ಲಿ ಇಲ್ಲ, ಅದನ್ನ ಮಾಡಕ್ಕೆ ಹೋಗ್ತಾ ಇದ್ದಾರೆ.
Annexure C
yes, my lord,
is this portion, and there is a Nala running here.
Yes, my lord, there is no difficulty.
That is what they have shown.
Annexure C, my lord, is survey number 33. Annexure D and Annexure, my lord, E pertain to survey number 34. The Nala is in 34. Survey number, my lord, 33 is Annexure C, which belongs to me. Other two, my lord, sketches which my lords were pleased to see is 34, my lord. So the Nala is running in 34, in 75 also, and as per the latest sketch. Now they are trying to form, my lord, a Nala in 33. Photographs are there, my lord, which my lords will kindly see.
$33 is your property.
33 is my property. Nala is running in 34. Now, if my lords were to kindly see the photographs, for the first time, my lord, they are making a Nala in our property, Annexure G, page 28, if my lord sees. Now, if my lord sees, my lord, Annexure G, this land is also converted, my lord, conversion order is produced as Annexure F. Survey number 33 is converted. Now, my lord, Annexure G, now they are, my lord, making a Nala for the first time by excavating.
And no Nala was found.
No Nala was found.
Permission is granted. And
Land is converted.
Converted.
Yes, my lord. And now, my lord, annexure G1, it is a fresh excavation that they are doing.
But only 21 guntas.
Yes, 21 guntas. Out of, we are also claiming only 21 guntas, my lord. Our schedule is also 21 guntas. We are also claiming 21 guntas. Now, please see the photographs. Annexure, my lord, G1, G2, G3. For the first time, my lord, they are using a JCB and my lord, making a nala in the middle of our property. And my lord, annexure G5 at page number 33 shows the existing nala, which is running all along the property. If a G5 photograph, my lords will kindly see, this is the nala running all along 34. Right side ali JCB iradu 33. They want to now make a nala through my land and make a new connection to the existing nala. That they cannot do. They should put me on notice. Nothing is done. And even if G5 is seen, my lord, on the right hand side of the photograph, my land is at an elevation. Through the property, my lord, they want to create a nala in the middle of my property. Google map, my lords, will kindly see G4, my lord. Google map mele. My lord, that rectangular portion is survey number 33, my lord, this on top. Annexure G4. On the left hand side, there is a.
Where is this property? Bangalore city.
My lord, this is in yes,
Bangalore city.
Bangalore, outskirts of Bangalore.
Even outskirts.
Whitefield, Kyapuram.
Huh?
Whitefield, Kyapuram.
That is also part of Bangalore only.
Yes.
Huh?
Yes, yes.
We are directed that these matters should be listed in the before the other court dealing with the LB matters, because many such cases were filed.
Yes, please.
And most of them were filed there before the bench having LB roster. Only a few were filed here.
My lord, that was an action, my lord, which was taken by the corporation in demolishing the buildings. But this is where the revenue authorities are trying to, my lord, dig and make a way.
The same thing. In pursuance of the orders passed by.
Lord, those orders, that is what they say, my lord. But those orders were passed in 2011, my lord, annexure B. The reference that they give is the reference to annexure B 11 years, lord, now 12 years ago. Now, for the first time, my lord, the sketch comes. 2012, my lord, land is converted.
All right. Planet, let's see the takes notice for.
Lord, respondents.
Then Node, see 4, 5, and 6. 4,
Yes.
6 are BBMP.
BBMP, yes.
If that court is dealing with these kind of matters, it is better that this matter be placed there.
But this is a revenue sketch, my lord.
Same. The assistance of the revenue authorities are taken by the BBMP because they hold the records of the survey.
Yes. I have no difficulty, my lord, any court, but then, my lord, there is some urgency till it is, my lord, taken up. Some protection can be granted, my lord. It is a converted land.
Learned HCDP takes notice for response number 1 to 3 and 5. BBMP ಯಾರ ಹತ್ರ ಹಾಕ್ತಾರೆ?
ದೇವೇಂದ್ರಪ್ಪ.
ಆ ಮ್ಯಾಟ್ರಿಕ್ಸ್ ಅಲ್ಲಿ issue emergent notice to response number 4 and 6. Learned counsel for the petitioner is also permitted to serve ಅಲ್ಲ ಇನ್ನೊಬ್ರು ಯಾರೋ ಅಪಿಯರ್ ಆಗ್ತಾರೆ ಈ ಮ್ಯಾಟರ್ಗಳಲ್ಲಿ.
Ascertain it, sir.
To serve a copy of the petition on any of the panel advocates of the respondent BBMP and a copy on the learned AGA. Stop. Next para. Learned counsel for the petitioner submits that the respondent authorities appear to have taken action consequent to an order passed by the Honorable Division Bench in a public interest litigation in WP number 31394 of 2009, dated 4th of August 2011, wherein directions were issued to the BBMP to remove the encroachments over the stormwater drains in Bangalore city. So, learned counsel submits that the petitioner is the owner of 21 guntas of land in survey number 33 of Whitefield village, Yarpuram Hobli, Bangalore East Taluk. Stop. The learned counsel has filed a memo dated 11/1/2023 along with the schedule of the property in question along with the boundaries. So the same is taken on record. Next para. Learned counsel has drawn the attention of this court to
Annexure F, page number.
annexures E and F, annexure E, annexures D and E, to submit that at an undisputed point of time, these sketches were prepared and it is seen that the Nala runs on the periphery or boundary of survey numbers 34 on the one hand and on the other side survey numbers 33, 32 and 35. Full stop. In terms of annexures D and E, the Nala does not run within survey number 33. Stop. However, it appears that a survey has got prepared at the hands of the surveyor at annexure C to show that the Nala is running within survey number 33, measuring 21 guntas. Stop. The learned counsel has also drawn the attention of this court to the photographs at annexure G series and more particularly annexure G5, which is a photograph which clearly shows the existing Nala or stormwater drain. Stop. Learned counsel submits that when that is the position, it is impermissible for the respondent authorities to now carve out a drain within survey number 33. And it would be contrary to the earlier sketches which show that there is no stormwater drain running within survey number 33, comma, more particularly an extent of 21 guntas belonging to the petitioner. Full stop. Next para. Consequently, the respondent authorities are directed not to take any precipitative action and the parties shall maintain status quo in respect of the land in question as on today. Comma, until further orders. Full stop. Next para. Office is directed to place this matter before the bench having the roster of local bodies, comma, since many such petitions wherein the action was taken both at the hands of the revenue authorities as well as the BBMP were directed to be listed before the bench having the roster of local bodies. NR Jagdishwar. The petitioners are also permitted to serve a copy of the petition on learned counsel Shri NR Jagdishwar
for hand delivery. Great.
Apostle. Yes.
For the petition. My lords, this is a case wherein the petitioner's husband was granted land temporary Sagoni CT as per annexure A, my lords. Page number 13 is the typed copy of annexure A. As per order RD 105 GP 77 dated 1 September 1977. Subsequent to which the RTC stood in the name of the petitioner's husband, my lords. Annexures C and C1, my lords. Yavappa Shetty is the petitioner's husband's name. Annexure B is the temporary Sagoli Chiti which was issued to petitioner's husband. Page number 17 is the typed copy.
Annexure A is not a grant order.
No, my lord.
Huh?
Annexure.
Yes. Please read annexure H.
Please. Annexure H, my lord, that is the order. Please. 33. ಹಿಮ್ಮರಹ ಚಿಕ್ಕಮಗಳೂರು ತಾಲೂಕು ಕಸ್ಬಾ ಹೋಬಳಿ ಹೆಬ್ಬಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 1ರಲ್ಲಿ 3.05 ಎಕರೆ ಜಮೀನು ಶ್ರೀ ದ್ಯಾವಪ್ಪ ಶೆಟ್ಟಿ ಬಿನ್ ತಿಪ್ಪಶೆಟ್ಟಿ ಅವರಿಗೆ ತಾತ್ಕಾಲಿಕ ಪ್ರೊವಿಷನಲ್ ಸಾಗುವಳಿ ಚೀಟಿಯಂತೆ ಹಂಗಾಮಿಯಾಗಿ ಮಂಜೂರಿಯಾಗಿದ್ದು ಕಾಯಂಗೊಳಿಸಲು ಕೋರಿರುವ ಬಗ್ಗೆ ಸರ್ಕಾರ ಸುತ್ತೋಲೆ -1977 ನಂಬರ್ 2 ಸರ್ಕಾರ ಸುತ್ತೋಲೆ 2009 ಲಕ್ಷ್ಮಮ್ಮ ಕೋಂ ದೇವಪ್ಪ ಶೆಟ್ಟಿ ಅವರ ಮನವಿ 6/8/2022 ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ಚಿಕ್ಕಮಗಳೂರು ತಾಲೂಕು ಕಸ್ಬಾ ಹೋಬಳಿ ಹೆಬ್ಬಳ್ಳಿ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 1ರಲ್ಲಿ 3.05 ಎಕರೆ ಜಮೀನು ಸರ್ಕಾರ ಸುತ್ತೋಲೆ ಸಂಖ್ಯೆ -77 1977 ಪರಿಮಿತಿಗೆ ಒಳಗೊಂಡು ದ್ಯಾವಪ್ಪ ಶೆಟ್ಟಿ ಬಿನ್ ತಿಪ್ಪಶೆಟ್ಟಿ ಅವರಿಗೆ ತಾತ್ಕಾಲಿಕ ಪ್ರೊವಿಷನಲ್ ಸಾಗುವಳಿ ಚೀಟಿ ಕ್ರಮಾಂಕ K-23/9/77 ಮಂಜೂರಿಯಾಗಿತ್ತು. ಕೈಂಡ್ಲಿ ನೋಟ್ ದಿಸ್ ಡೇಟ್ 23/9/77 ಖಾತೆ ಬಂದಿರುತ್ತದೆ. ತದನಂತರ 2014 ಶ್ರೀಮತಿ ಲಕ್ಷ್ಮಮ್ಮ ಕೊಂಬದೇವಪ್ಪ ಶೆಟ್ಟಿ ಪೌತಿ ಮೇರೆಗೆ ಖಾತೆ ಬಂದಿತ್ತು. ಸದ್ರಿ ಅವರು 6/8/2017 ಮನವಿ ನೀಡಿ ಕಾಯಂಗೊಳಿಸುವಂತೆ ಕೋರಿರುತ್ತಾರೆ. ಸದ್ರಿ ಅವರ ಕೋರಿಕೆಯಂತೆ ಪರಿಶೀಲಿಸಿದರೆ ಸರ್ಕಾರ ಸುತ್ತೋಲೆ ಸಂಖ್ಯೆ -77 ಆದೇಶದಂತೆ ತಾತ್ಕಾಲಿಕ ಸಾಗುವಳಿ ಚೀಟಿ ನೀಡಿದ ಪ್ರಕರಣಗಳಲ್ಲಿ ತಾತ್ಕಾಲಿಕವಾಗಿ ಮಂಜೂರಾಗಿರುವ ಬಗ್ಗೆ ಇಲಾಖೆ ನಿರ್ವಹಿಸಬೇಕಾದ ಸಾಗುವಳಿ ಚೀಟಿ ವಹಿ ಮತ್ತು ಮೂಲ ದರಖಾಸ್ತು ಕಡತ ಪುಸ್ತಕ ಲಭ್ಯವಿರುವುದಿಲ್ಲ. ಅಂತಹ ಪ್ರಕರಣಗಳ ಸುತ್ತೋಲೆ ದಿನಾಂಕ 2/6/2009 ಖಂಡಿಕೆ 1-2-3 ಆದೇಶದ ಅನುಸಾರ ಪ್ರಸ್ತುತ ಪ್ರಕರಣದಲ್ಲಿ ಕಾಯಂ ಮಂಜೂರಾತಿಗೆ ಅವಕಾಶ ಇರುವುದಿಲ್ಲ. Kindly see.
Yengri, on the one hand, you say that their names have been entered in the land records and it has been continued. After the death of the original grantee, the name of the wife is mutated and entered in MR number 5 of 2014-15. How can you now say, no, hangami sagoli chiti dakhlegulu labhya illa anta artha enu? Then how did you have their names entered in the land records? Bakale. Learned AGA takes notice for all the respondents. Learned counsel for the petitioner is directed to serve a copy of the petition on the learned AGA. Full stop. Next para. Learned senior counsel Shri P.P. Hegde, appearing for the petitioner, submits that the petitioner's husband Shri Devappa Shetty was granted 5 acres and 3 guntas of land in survey number 1 of Hebbali village, Kasba Hubli,
3 acres and 5 guntas. 3 acres and 5 guntas. 3.05.
ಏನು ಹೇಳಿದೆ ನಾನು?
3
acres 5 guntas.
I'm sorry.
Temporarily on 23/9/1977. So, after the death of Shri Devappa Shetty, the petitioner herein got her name entered in the land records by way of MR number 5 of 2014-15. So, the petitioner made an application on 6/8/2022 seeking permanent grant of the land, recognizing the fact that earlier a temporary grant was made in favor of the grantee. Full stop. The Tahsildar has issued the impugned endorsement dated 5/9/2022, rejecting the claim of the petitioner on the ground that the original records to evidence the fact that the land in question was granted in favor of Shri Devappa Shetty temporarily is not found. Stop. Learned senior counsel submits that the Tahsildar could not have issued the impugned endorsement because it would run counter to the revenue records, which clearly show that the name of Shri Devappa Shetty was entered in the land records from the year 1977. 78-79. And subsequently, in the year 2014-15, the name of the petitioner was entered in the land records after the death of the original grantee. Stop. the petitioner has remained in continuous occupation of the land in question and has been paying the taxes. Stop. Expira. Consequently, the respondent authorities are hereby directed not to evict the petitioner from the land in question until further orders.
And also not to change the record of rights, my lords. They will change the record of rights pursuant to this now, annexure H, and that will be again.
They shall not change the land records, which shall be maintained as it is prior to the impugned endorsement dated 5/9/2022. Yes.
Great.
Statement, next para, statement of objections shall be filed at the hands of the respondents within a period of 2 weeks from today.
And application seeking for dispensation of furnishing of originals.
Mikiddo?
I'll do it in 2 days.
On 4/1/2023, the following order was passed. Expira. The office objections have not been complied with. Full stop. Consequently, the writ petition stands, the CMP stands dismissed.
Application. Number 44. An application, seeking a paper publication.
ಮೂರು ಸರಿ ತಗೊಂಡಿದ್ದೀರಾ?
Complete ಆಯ್ತು.
ಯಾವ ಅಡ್ರೆಸ್ ತಗೊಂಡ್ರಿ? ಎರಡು ಅಡ್ರೆಸ್
Both address, madam. Thrice I have taken on both address, madam. Not claimed ಅಂತ. Not only in this matter, my connected matter, second matter also, same respondent on both address matter, that petition also, the notice unserved as.
ಎರಡು ಅಡ್ರೆಸ್ ಕೊಟ್ಟು ತಗೊಂಡಿದಾರ ನೋಡಿ. ಕವರ್ ನೋಡ್ರಿ ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ. ಎರಡು ಇದೆಯಾ ಕವರ್? ಅಡ್ರೆಸ್ ನೋಡಿ. ಬೆಟ್ಟದಾಸಪುರ ಒಂದ್ ಎರಡು ಅಡ್ರೆಸ್ ನೋಡ್ರಿ. ಒಂದು ಬೆಟ್ಟದಾಸಪುರ, ಇನ್ನೊಂದು ದೊಡ್ಡ ತೋಗೂರು. ಅದ್ರ ಕೆಳಗಡೆ ಬೆಟ್ಟದಾಸಪುರ, ಇದು ದೊಡ್ಡ ತೋಗೂರು ಕೆಳಗಡೆ ಇದೆ ನೋಡಿ. ಒಂದೇ ನೋಟಿಸ್. ಅದೇ ರೀ, ಒಂದೇ ಸರಿ 3 ಸರಿ ತಗೊಂಡಿದೀವಿ ಅಂದ್ರೆ ಎಲ್ಲಿದೆ?
On 26/8/2022, on both the address I have taken steps, madam. On next date, madam, 1/10/2022, I have taken one address, below address.
I mean, in third time, 9/12/2022, first address alternative in connected matter also, my lord,
And you have not stated that you have taken notice thrice.
what happened, my lord?
In your application affidavit, you have not said that you have taken notice thrice.
Thrice, I can, last time, after taking two steps, my lord, I have filed application. My lord, previous date of hearing, last was to defer the application, consideration of application. Because of, my lord, one more steps has to be taken. After I have taken one more.
Or on IA number 2 of 2022. The application is filed by the petitioner. Or Order 5 Rule 20. Seeking permission to take out substituted service on the respondent by way of paper publication. So, Learned Counsel for the petitioner submits that there are two addresses given in the cause title in respect of the respondent, and notices have been taken on both the addresses. So, notice have been taken 3 times, and the respondent is evading service. Stop. Expert. Consequently, the application is allowed. The petitioner is permitted to take out paper publication for service of notice on the respondent in Kannada daily newspaper Vijayavani, Bangalore edition on or before 25th of January 2023. Full stop. The next date of hearing shall be 8th of February. Same order, next matter will be.
For the respond number 1, my lord.
For appointment of an arbitrator, section 11 petition. There was a joint development agreement that was entered into between the petitioner and the respondent number 1. Previously.
You have filed this application.
I filed this application
to strike out respond number 2.
in relation to that, I just have 3 submissions to make. This JD was pertinent to a different project to which I was not an RP professional member. The same was also held by NCLT Bangalore wide their order, my lord, and same is also produced along with my statement of objection. My lord, in this particular CARP proceedings, my lords, it was done project wise, my lord, and not with respect to all the projects of the company, my lords, as laid down in Flat Buyers Association Winter Hills versus Duman Realty, my lords. So, my lords, my role in this entire JD and with respect to the project patios that they referred to, my lords, is not at all required, my lord, and I am no part, I am not even in the role of the resolution professional at the point, my lord, because my resolution plan was approved and the same was taken on record on 4th November 2022, my lord. I will no longer hold the role of the resolution professional of the company. Even when I did hold the role of the resolution of the company, I was only dealing with the direct outcome project Arun Aurobill, my lord, respondent number 1, but not with respect to Arun Patio, my lord. The same is also an admitted position by the petitioner here in my lord, where he is also a home buyer in Arun Aurobill, my lords, and they come before the COC and made the submission, and we also observed and recorded that is being produced, my lords, before this honorable court, that these claims cannot be raised here, as NCLT Bangalore has specifically held that I have no power to look into these claims, my lords, as I was only appointed for project specific CRP proceedings. So far as I am concerned, my lord.
Yes, what do you say?
The Lordships may kindly appreciate, in fact, on the last occasion when the matter came up. In fact, so far as the application, if the arbitrator is appointed, your Lordship would decide as to who would be the respondent before the arbitrator. Full submission is this.
No.
One submission, Swami. Idralli, your Lordship may kindly take the first title, page 6. The company, that is the respondent company, while I had filed the first CMP, while it was pending, they filed a application, brought it to the notice that NCLT petition is there, because of which this court disposed of the CMP with the direction, with the liberty. The Lordships may kindly appreciate. Then we were made to run between the first.
Anyway, you have respond number 1.
Swami,
what is the difficulty?
They are denying that they are the persons to be, they are the parties and that being the case, I was made to run between respondent 1 and 2. That is the reason why I made both of them the parties in this petition. My humble submission is this. He may be right or he may be wrong. My humble submission is this. Petitioner number 1 is the person who would be the contesting party insofar as my project in respect of joint development agreement. I have entered into an agreement while the company was in progress. During the pendency, it went before the NCLT. Adu close agutide Swami. What he says 4/11/22, it is closed. But my humble submission is the arbitrator may be appointed. The IA need not be considered. In fact, the IA would of its own get disposed of. The arbitrator is appointed. As against the petitioner and respondent number 1, the arbitration has to continue. My humble submission is this. In the respect of any real estate project, in any insolvency and bankruptcy court, the proceedings would be project specific. Illi, the project previously that was under CIRP, that is Corporate Insolvency Resolution Process, was in respect of Arun Aurobill. Namadu, it relates to a project where I am the landholder. A joint development agreement was entered into in respect of a project called Arun Patios. That is in no way concerned with the entire project. Even though the CM,
you are the owner of the land.
I am the owner of the land. I am being put into problem. In fact, I am stuck. In fact, the NCLT proceeding has nothing to do with my case. Arbitrator has to be appointed and the matter has to be adjudicated by the arbitrator. Development. And while I came before this court, for honorable court for appointment of an arbitrator, matter was taken up before the NCLT. Hagagi moratorium ide anta heli madidru. My humble submission is even then we went before the NCLT and we went before the resolution professional and they gave a clarification telling this matter would not come up before the resolution professional. NCLT munde idu barala anta heli they gave a clarification. Then we filed the second CMP. The second CMP, unfortunately, when it came for consideration, the name of the arbitrator is not proposed in the notice and table. On that ground, it was dismissed with a liberty. As such, notice was reissued and we are now before your Lordships. Now, the respondent number 1 comes up with some frivolous objection. He has filed an objection today. Frivolous objection, absolutely no defense. The only contention, my humble submission is, whatever is your position, it has to go before the arbitrator for contention on merits. So my humble submission is, whether the second respondent needs to be discharged or not would automatically be decided when the matter is referred to arbitration before the honorable arbitrator between petitioners and respondents.
After all, you are only a resolution professional. You have no personal interest in this matter. All right. Yes, what is your objection?
First, my lords, company Arun Shelters Private Limited went in for a resolution process before the court, before the NCLT, my lord.
Sir, we are not concerned with that.
No, my lords, promoters, Arun Shelter.
The petitioner before this court is the owner of the land
Yes,
with
my
whom
lord.
you had entered into an agreement.
Company, sir, my lords, there is a difference now
It is the
here.
company, it is the company that entered into an
My lord,
agreement.
Arun Shelter Private Limited, I have been suspended, my lord. That company is may not have taken over by the person who has taken over the Arovilla project, my lord. I am a suspended promoter.
Therefore, that was only in respect of a particular project.
No, my lord, whole company is there. Unless demerger happens, I cannot represent the company, my lord. There is an order produced by him that Arovilla project has demerged. A special purpose vehicle has to be created by the person who has taken over the Arovilla project. Thereafter, Arun Shelter company will be released. Then I will come into the picture. I am suspended promoter now. If your lordship directs me to take the company, I am happy, my lord.
Where is that order of the NCLT? Please show that.
Yes, my lord. In statement of objections, my lord.
Yes.
The respondent number 2 has filed that, my lord. There is a specific order in para 40, my lord, page 79 of the statement of objections filed by the respondent number 2, my lord. Unless a demerger happens, I cannot take the responsibility of the company. That is in process. I am happy to take my company.
Page number
So,
79.
para 40, 17, page 17, para 40, my lord.
Yes.
In these circumstances, for the aforesaid reasons, the instant IA bearing number so and so is allowed according to the resolution plan dated so and so along with the scheme of demerger. The resolution plan submitted by the so and so in the so and so which is annexed and marked as annexure K to the application is hereby approved. The resolution plan so approved shall be binding on the corporator, its employees, members, creditors, including the central government and the state government, any local authority to whom a debt in respect of the payment of dues arising under any law of the time in force, such as authorities whom statutory dues are owed, guarantors and other shareholders involved in the resolution plan. Under the provisions of section 31 subclause 3 code, we also direct that bank guarantee so and so on. Here, this demerger plan will happen when special purpose vehicle is created by these two persons, SF Kamal Pasha and Golden Hatcheries and Syed Pahar. They have to create a special purpose vehicle, take over the Arovilla project, then they have to release the Arun Shelter. Then the suspended director, I am a suspended promoter, having a right to take the company, my lord. That is my objection. I am happy. Your lordship direct me to take over the company. I am happy. As per the order, I have been taken. Yes, my lord.
No. Please understand. There is no difficulty. It only says the resolution plan will be binding on all of you.
My lord.
Whatever happens there will happen.
Huh? I am a suspended director. My suspension is not revoked. Yes, my lord. Page 61, para E, my lord.
Sir, you are required to defend yourself in respect of the arbitration clause in the contract binding you with the petitioner.
You cannot represent the company, my lord.
If the verdict of the arbitrator goes against you, while executing that award, the arbitrator will have to take into consideration the resolution plan approved by the NCLT. That is all.
I cannot represent the company. I am a suspended
director. Where does it say so?
Yes, page 61, my lord. Yes, page 61, para E, my lord. Arun Kumar is a suspended director. We have opposed that petition, para E. As regards to the raised by the suspended director that the resolution plan value is less than the liquidation value, it is stated that Honorable Supreme Court in so-and-so case held that it's an absolute discretion of the COC to approve the resolution plan. Liquidation value is merely to assist the COC in deciding about the resolution plan and in the commercial viability. Therefore, the said objection is not in accordance with law. So I am a suspended director. I cannot take the company, my lord. It amounts to contempt. I have filed the wakalat for Arun Kumar as a suspended director, not for the company. If lordship clarifies that I can represent the company, I can, my lord. Still, my suspension is not revoked. It will be revoked when the special purpose vehicle is created, when the that around Arovilla's project is transferred to the special purpose vehicle.
Where is the order of suspension, sir?
Yes, ma'am. I will take a last.
Where is the order of
Moratorium
suspension?
period, 31, madam. 31/1/2000, madam.
Page number?
Is the election A, madam. Page 18. Page number 9, relevant page 19, madam. Corporation insolvency resolution process in respect of Arun Chetzer Private Limited on the ground that it has committed a default of total so and so amount, 9th so and so as on 36/2008. The brief facts are given, my lords. Then, my lords, a moratorium period was declared. At page 25. Following moratorium is declared prohibiting all the following, namely the institution, etc. B may be kindly seen, madam. Clause A. The institution of suits, continuation of the pending suits or proceedings against the respondent corporate debtor. Arun Chetzer Private Limited is a corporate debtor, madam. Including execution of a judgment, decree or order in any court, tribunal, arbitration panel or other authority. So during the pendency of this moratorium period, this notice was issued, this arbitration proceedings were initiated, order was passed, final order was passed 4/11/2022, my lord. Can they initiate?
There are 2 submissions. This moratorium is in respect of this particular project. Even for a moment, if it is considered, one submission, even if it is considered to be the entire company, your lordships may kindly see page 79. There it says the moratorium order passed by this adjudicating authority under section 14 of the code on 31/1/2020 in the main CP ceases to have effect. Ceases 79 from page number 79. The last paragraph, B. The moratorium order, I quote, the moratorium order passed by the adjudicating authority under section 14 of the code on 31/1/2020 in the main CP shall cease to have effect.
When?
Cease effect from 4/11/2022, page 49, Milords. Page 49. Page 49, effect from 4/11/2022, Milords. The resolution plan for scheme of demerger, wherein the Arun Olovilla project was demerged from Arun Shelters Company, and that was taken out, and the project was hived off for the resolution applicant, successful resolution applicant to take over, and the company Arun Shelters would continue its existence. So that being the case,
has to be continued by that only after special purpose vehicle is created by that.
And with effect from 4th November 2022, even the RP, that is the resolution professional, would not have any role. So with that, Milords, the whole proceeding closes. The Lordships may kindly appreciate on 31/1/2020, the proceeding commenced and closed with 4/11/2022. And it is not possible for the respondent number 1 to contend that there is a restriction on him.
Just make one submission with respect to this, my lords, to clarify further. Annexure B of my objections, my lords, clearly clarifies the moratorium and all the procedure that is followed thereafter is only with respect to one project, my lords. And that was further clarified in the order dated 29 June 2020 by the NCLT Bangalore, saying that the CRP proceedings only with respect to Arun Oroville and not with respect to any other project, my lords. Further, even we RP made an application in this regard, saying to include the other project that was being undertaken by R1 called Arun Park Goods, which was rejected subsequently, and I withdrew that application because I was not an agreed party, my lords. The agreed party in this case was Purvangra, and filed an application also got rejected, saying that this CRP proceedings only with respect to one project, my lords. Further, Purvangra, insofar as Arun Park which is concerned, has filed an appeal in NCLT, and it's pending there. So the contention with respect to the company is so far as false, my lords. Only project-wise CRP proceedings were conducted. Are contention.
Para number 32, regarding special purpose vehicle, para 32 of the page 76, once the special purpose vehicle is created, that if project is taken over, then I will be permitted that my suspension will be revoked. I may be the promoters are permitted to run the company, my lord. Para 32.
Yes.
Further, very rational behind the scheme of demerger as a part of the resolution plan is to ensure the business undertaking project around Aravilla, which alone is the subject matter of CIRP, is dealt with independently in the resolution, and that assets and liabilities of that are part of the business undertaking project of Arunavilla are segregated in favor of SPV of a RA, and RA shall discharge. RA means resolution applicant, my lord, who is successful bidder. In favor of RA, and RA shall discharge the liabilities of the project Arunavilla, resolve the CIRP. This will be ensure the project Arunavilla is continued as a going concern. So, my lord, he has to prepare a special purpose vehicle, take away this project to him, then he has to release the Arun shelters, then I will be restored my position, my lord. If the CRP says that I can run the company, I am very happy, my lord. That's not there in his position, my lord. NCLT has to clarify. My suspension is revoked. I can run the company. Yes, he is right. He is for Aravilla project. But Arun Shelters, I am a suspended promoter. My suspension is not revoked. After a special purpose vehicle is created, then that project will be transferred to Aravilla. Aravilla project is transferred to that RB, resolution applicant. Then my suspension will be revoked. Then I can represent the company.
Not my humble submission is there is no matter pending. There is no matter pending before the NCLT now. Absolutely no matter pending. And the entire aspect
They have to comply. Everything has to be complied, my lord. Report to the company.
What he is saying is, it is clear that the directors have been placed under suspension.
Not even for a moment, for all. If I may
even if we accept your contention, that the NCLT has clarified that whatever has to be done shall be done only in respect of one particular project, and the resolution professional is required to manage the entire thing, to see that the liability of the company, though it is to be taken out from that particular project, there is no specific order that the Arun Shelters, which is the company, can continue to run by the directors. There is no such clarification.
If I may submit, insofar as real estate project, the corporate insolvency resolution process is always project wise. The NCLT gave a clarification that this CIRP, corporate insolvency, confines itself only to Arun Aravilla. The RP takes charge of all the assets. The remaining assets, the remaining company is handled by the directors.
From where do you get that?
If I may draw a lordship's attention.
Where is the specific order regarding the suspension of the directors?
The suspension is only with regard to Arun Aravilla. If I may draw a lordship's attention to the.
How can it be, sir? They are not directors for a particular project. They are directors of the company.
They are directors of the company,
and their directorship has been suspended.
Even otherwise, it is recalled with effect from 4th November 2022, 2022 November is the first order, page 29, page 25. If I may draw a lordship's attention to page 25, the following moratorium is declared prohibiting all of the following. This order is recalled, wide order dated 4/11/2022 at page 79. Moratorium for all purposes is passed on 31/1/2020. Lordships may kindly refer. I draw a lordship's attention to page 25. The following moratorium is declared prohibiting all of the following, and that is removed. Wide order dated 4/11/2022 at page 79. Para B last para. Para B last para.
Para 79.
Page 79. Para B, the moratorium order passed by this adjudicating authority under section 14 of the code on 31/1/2020 in the main CP shall cease to have effect. So lordships may kindly appreciate the The paragraph that was read out by my friend, page 25, para 2A, if I may quote, the following moratorium is declared prohibiting all of the following, namely, A, the institution of suits or continuation of pending suits or proceedings against the respondent or corporate. So this is recalled. That is recalled, Minos. That is withdrawn. Page 79, Minos. In fact, para 2A specifies even about arbitration panel. The date of the order, your lordships may kindly appreciate, is 31/1/2020 at page number 18, Minos. Page number 18, if I may draw your lordship's attention. Annexure A, page number 18. Date of the order, 31st January 2020. Lordships may kindly appreciate the same order last, but penultimate page, page 25. Para 2A, the following moratorium is passed. So the same is recalled at page 79. The date of the order is 4/11/2022 at page number 49. The first page of the order is at page number 49. So the moratorium and the restriction, even for a moment, if the respondent contends that there is a moratorium on him and he is a suspended director, is no more in effect.
No, Manas. Moratorium is entirely different and suspension is entirely different. Company is taken over by the COC, Committee of Creditors, headed by the PRP. The COC is the board of directors.
Please think over.
If I may just
whether it was right on your part to file this application. Because please understand, you please see annexure G. The first meeting that was conducted after the case was closed by the NCLT. Now everything has to be done by you in your chairmanship. That is what you have been doing at annexure G. Now, would it be permissible for you to submit? I will have to resolve the differences between the company and the creditors, in whose favor the NCLT has passed the orders. Only by taking into consideration one particular project of the company, and the company is free to do whatever it wants in respect of the other projects.
Yes. Also, in relation to this, IRP was appointed on in annexure A 31/1/2020, an order passed, and IRP was appointed in relation to this resolution process, my lords. And IRP had constituted only a project specific COC, my lords. That was the impediment that has caused all of this, my lord, which in fact is allowed by the NCLT, my lord. Further, as so far as I am concerned, position of the resolution professional, my lord, I find to include all the not available. Even the annexure G, which is referred to, with respect to all of my lords, also a home apart from all of the contributions raised with respect to Arun patios, both this minutes of meeting is concerning Arun Auroville, my lords. He had made his claim as a home buyer, my lord, which is also recorded in that board resolution.
Point number 8. Point number 8.
Point number 8. Also, I would base my reliance on the Supreme Court order in Committee of Creditors of SR. It clearly states upon approval of the resolution plan, the RP no longer can. I will read out the relevant paragraph. But the Supreme Court of India and Committee of Creditors of SR Supra has said that the detailed provisions of IBC 2016 regulations make it clear that the RP is a person who is to manage the affairs of the corporate debtor as an ongoing concern from the stage of admission of under section 7, 9, and 10 of the code. Plans approved by NCLT.
Yes.
Subsequent to which I have no role to play, and NCLT states that I should not go beyond the ambit of the commerce, consider any
No, it's not about that. See, if you are permitting the directors of the company to run the show in respect of the other projects, will they not be able to do something that will have an effect on this project also? Are they not capable of doing it?
I not directly comment on that, my lord, but my only submission is that there are 3 projects which Arun Shelters is involved in, my lord. Same, so far as Arun Parks is also concerned, there are petitions which are pending before the NCLT, like I submitted. My lord, I am not arrayed as a party because Arun Parks was never under my purview, my lord. Only Arun Parks was under my purview. That is the confusion which has been continued to exist in this particular CIRP proceedings, which I seek to clarify that even if I am arrayed as a party in these proceedings or any other further proceedings, I have no role to play or no so far as that is submitted. All orders that I produced before this court, my lords, clarify the same matter. Annexure C, it is an order passed on 11/9/2020, my lord. It is at page number 34. At page number 37, there is order, my lord. CBIB number 305 BB of 2018 is hereby allowed appointing Ms. Shripriya as a resolution professional in respect of the corporate debt. Is directed to expedite the CIRP terms of the provision of the code and executive rules. But again, I made a specific application, my lords. Subsequently, it was again rejected. So my hands were tied in so far as whatever claims the other creditors had brought forward before me, because there was nothing that I could do as per the NCLT order, NCLT Bangalore order.
Let's add it to this here, my lord. Arun Shelters Private is a corporate debtor. For a corporate debtor, moratorium period was declared and RP was appointed. Another important aspect of that, petitioner number 1 is a part of COC of that Arun Aruvidla, and he is bound by the order passed on 4/11/2022. Petitioner 1 herein is also part of COC. I will take your lordship to that, my lord, at page annexure G, page 81.
But there's one thing. See, they have pointed out from the final order that the earlier order regarding the
moratorium. Yes, my lord. I must say moratorium is no more. Yes, my lord. But
therefore,
suspending under moratorium, I have not been suspended, my lord. By admitting the application, I was suspended, and I was replaced by a RP, temporary resolution professional. Then a COC was been formed, COC of the creditors, chaired by the RP. He is heading the creditor, corporate debtor. He is heading the corporate debtor with a company. Now, and that corporate debtor is headed by COC, is like a board of director now. That board of director earlier is gone. COC is the board of director, of which petitioner number 1 is a member. I will take a lordship annexure G, page 81. He is also a member of COC. Participated in the COC, and he agreed for a appointment of the RP and resolution approval of the resolution plan. And he is bound by 411 order. Annexure G, page 81. Statement of objection filed by the RP, my lord. A tabular form, my lord, serial number 4, Shashidhar Muniyappa, petition number 1 hearing. He is a member of COC of Aruvedla. Can he come and say that it's not binding on me? And there is an order on 411, all stakeholders are bound by it. One step, he is a member of COC. Shashidhar Muniyappa, my lord. Annexure G, 4th serial Supriya Kumar Acharya. Yes, my lord.
Home buyer.
In Aruvedla.
Shashidhar Muniyappa is also a home buyer in this project. I may take your attention to paragraph number, point number 8 in the same annexure, my lord, at page number 83. Discussion on the matter of JDA of Arun patios. One of the members of COC, Mr. Shashidhar Muniyappa, brought to the attention of COC about the High Court order passed in the matter of joint development agreement between Mr. Shashidhar Muniyappa and others, and the corporate debtor in CMP number 36 of 2020. Wherein he stated that the High Court has directed the appellants to approach the resolution professional on the matter with the liberty to agitate the claim if necessary. The matter was discussed and the members of the COC stated that the present COC, which was constituted for Arun Oroville under the orders of IN 187 and 195 of 2020, would not be able to take a decision on that matter.
That's correct.
Other members present in COC also unanimously agreed that with regard to Arun patios, Mr. Shashidhar Muniyappa may approach the Honorable High Court for suitable reviews.
Subsequent to which we filed the second CMP. Subsequent to which we filed the second CMP.
Entire
moratorium also produced case
during
law.
the pendency of the moratorium period, he cannot initiate an arbitration proceeding. Number one. Number two, he is the company is still not handed over to the erstwhile promoters.
You are Shashidhar Muniyappa.
I'm the petitioner.
Huh?
Yes, my lord. Petitioner.
That's number one.
I am also a home buyer in respect of one home in Arun Oroville. That is all. And I brought it to the notice of the resolution professional, the committee of creditors in the meeting, that the CMP was dismissed or with the liberty. First CMP.
The honorable
the
court
liberty to approach the
directed.
resolution professional, and that is considered at page number 83 minutes.
My lord,
And having
this
discussed
honorable
it,
court-
it was decided that the RP resolution professional would not have the jurisdiction.
How long would this take to clear this?
It's already
task?
done. It's already done. My lord. The taking over of the company wouldn't be so far as our hands or under our authority, because we are no longer the RP in this matter. Because once the resolution plan was approved on in November 2022, I ceased to exist as the RP. I have no authority.
No, not that. This task that has now been entrusted to the COC.
No.
Where you are the
That is of 2021. It's page 81, if I may just draw your lordship.
81. Yes.
How from? That is of the 22nd February 2021. So that is done. If the last, the top, that's the heading, the last line on Monday, the 22nd February 2021. So the meeting was held on that day, and that is resolved that the RP does not have the jurisdiction. Then I approached this honorable tribunal, honorable court. Subsequently, in 2022 November, it is disposed of. So my humble submission is the RP wouldn't have any jurisdiction by virtue of this meeting minutes.
I'm asking how long it will take for the resolution of this plan that has already been ordered by the NCLT.
Annexure K is not furnished by the respondent number 2.
I cannot state a particular fixed period, my lord, based upon all the approvals and all the other requisite procedures that have to be followed. But it's already done, my lord. What submission is so far as when it shall be done. But it's already done upon the order passed by the NCLT. So only the pending procedures which follow are happening between the subsequent purchaser, my lord, in favor of whom the resolution plan was approved.
The respondent number 1 wouldn't have any role insofar as the demerged undertaking, that is the Arun Oroville ambulance.
It is
The rest of the
challenged by
company has to
me
be
the
controlled
individual
and,
capacity
run.
before the
If I may
NCLT.
just draw your lordship's attention to the judgment that I have relied upon. I have furnished the case laws. I dated.
How is it that you were able to get these orders in respect of another project, and you are not able to get the same relief in respect of the another project?
That's the NCLT admitted insofar as that particular project. Our dispute throughout has been that he's not even started the joint development agreement, the construction project as per the JDM. So my humble submission is we never approach the NCLT so far as our project is concerned. There is a contract, there is an arbitration
So
clause.
in respect of
Arun Pesho, that is our project.
Auro Villa,
Yes.
you are only a home buyer.
I am a home buyer first.
In whereas in this project, you are the owner of the
I am
land.
the owner of the land.
Your worship have asked time limit, my lord. Page 75, para 27. 12 months time period is given from the date of adjudication, my lord. Page 75, para 27 of statement of objections, my lord. Your lordship asked me the question when it will get over.
Where is that?
I will just para 27, page 75 of statement of objection filed by the respondent number 2, my lord. The plan shall be 27.
Completed in 12
Pursuant
months.
to regulation. Pursuant to regulation. Statement of objection, para 27, my lord. Pursuant to regulation 33(3)(c) of the CIRP regulations regarding whether the resolution plan has been provisions for its effective implementation, it is inter alia stated that in para number 15 and 22 of the resolution plan, pages now 168 and 178 of the application, that the resolution applicant has sufficient financial and operational capability to execute the project. The resolution plan clearly indicates the source of funds, implementation of the schedule, and the supervision during the implementation, and repayments are expected to be completed in 12 months from the date of approval by the adjudicating authority. Adjudicated approval on 4/11/2022. Within 12 months, he has to take over that project and release the Arun Shelters Private Limited.
But he would take that project and complete. We are in no way concerned with that particular project which is being taken over. But in fact, I have produced some case laws which clearly brings out that reverse CIRP process is to be accepted in real estate projects, which is project wise. If I may just draw your lordship's attention, wherein this case has been referred frequently. Flag Buyers Association, Winter Hills, 77 Gurgaon versus Umang Realtek Private Limited. But very clearly brings out the reason why real estate projects have to be page 27.
27 of
the case laws that I have found, the paper book, the compilation. Yes.
This one.
Yes. Page 27. This is observations on findings of this appellate tribunal. This is of the National Company Law Appellate Tribunal. In para 21, I quote, in corporate insolvency resolution process against a real estate, if allottees, that is financial creditors or financial institutions or banks.
Company appeal.
Yes, this is company appeal. Insolvency number 926 of 2019, first page. The cost title is Flag Buyers Association, 27 Gurgaon versus Umang Realtek Private. This was the first case law where the reverse CIRP process was brought in respect of all the other companies, the entire corporate debtor that would go in. And this has also been upheld. Subsequently, there was an amendment to section 7 of the IBC. Subsequently, that has been upheld. Even that judgment of Manish Kumar is also produced. Page 35 onwards, I have produced the Supreme Court decision when it upholds the reverse CIRP process in respect of real estate projects, which confine itself only to project specific and not the entire company. So the other, so far as the aspects other than the specific project which is in corporate insolvency process would be continued to be taken care by the directors, and it would continue in the company.
Please read it then. If it is there, it's already decided by the Supreme Court. Please point out.
Page 27, in corporate insolvency resolution.
That is an order of the NCLT. It's an order of the NCLT. Can't go by that. You please point out from the order of the Supreme Court.
But brings out the reason why the reverse CIRP has to be considered in real estate project. Page 35.
35.
Yes,
Yes.
If I may draw your lordship's attention to page 138 minutes. The rationale behind para 177 minutes. The rationale behind the running page 138, internal page 104 minutes. Para 177.
Yes.
The rationale behind confining allottees to the same real estate project is to promote the object of the code. Once the threshold requirement can pass the muster when tested in the anvil of the challenge based under Articles 14, 19, and 21, then there is both logic and reason behind the legislative value judgment that the allottees who must join the application under the impugned provisos must be related to the same real estate project. The connection with the same real estate project is crucial to the determination of the critical mass which legislature has in mind as part of its scheme to streamline the working of the court. If it is to embrace the total number of allottees of all the projects which a promoter of a real estate project may be having in one sense, it will make the task of the applicant himself more cumbersome. It becomes a sword which will cut both ways. This is for the reason that the complaints relating to different projects may be different. With regard to one project of a promoter of a real estate may be in the advanced stage, the allottees of a particular project may not have much of a complaint. The complaint in relation to yet another project may be of more serious. If the complaint in respect of the latter attracts the attention of a critical mass of allottees and the proposed applicant is part of that project in the said project, then it may be easier for the allottees to fulfill the statutory mantra in the impugned provisos with a junction of like-minded souls. If on the other hand, the requirement was to make a search for the allottees of different projects, as would be the case if the entirety of the allottees and the different projects were to be reckoned, the task would have been much more cumbersome. The requirement of the allottees being drawn from the same project stands to reason and also does not suffer from any constitutional blemish as pointed out.
These all case laws are pertaining to allottees approaching the NCLT against the developer. Their project-wise COC has to be constituted. That is the theme of amendment and the Supreme Court judgment, my lord.
Sir,
Not regarding the joint development agreement of the landowner and the developer.
It is for you to defend yourself before the arbitrator.
I am ready, my lord.
It will not be some other person, the resolution professional, who is going to defend you, because
if your lordship give me liberty, if a resolution professional says I can represent the company, I am happiest person, my lord. Let them put it in writing, my lord. I can represent the company. Otherwise, it amounts to contempt, my lord. Because when the resolution process is with the NCLT.
No question of contempt, because that.
I may humbly submit, my lords, the entire case was considered in the second CMP. While it was being allowed, my lords, the aspect relating to the notice came for consideration, where only the name of the arbitrator was not proposed, my lords. As such, it was rejected with a liberty, my lords. Then we issued a notice and proposed the arbitrator, and we are before your lordships again. In fact, the entire case was considered.
The wish is that till special purpose vehicle is created and the Aruvilla is taken off and the Arun Shelter corporate is released, I cannot take over the company. Otherwise, I would have been done in 2000 only, my lord. I am having another two projects.
We are not concerned with whether you are going to take over the company. That is not the thing. Now, we will only permit you to go and defend yourself before the arbitrator in respect of the contract between.
No, I have to represent the
contract
company,
enter between you with the owner of the land.
Company, my lord. It's a company.
Yes, company only. You are the director who entered into an agreement with this person.
I am suspended.
And only you will be able to substantiate or defend
once
yourself.
the suspension goes, my lord, if suspension goes, then only I can represent the company.
No, that we will cross that bridge when we reach the bridge. If there is an award against you, in the meanwhile,
I cannot
if there is an
represent the
award
company.
passed by the arbitrator in the meanwhile, whether that could be executed in the light of the resolution plan authorized by the NCLT,
the whole conduct of mine will be without authority, my lord. It will happen without authority because still my suspension is not revoked. And these two judgments are between the allottees and this is not applicable to
this will be in terms of the directions given by this court. So therefore, you will not worry about whether you will be hauled up for contempt. No.
Well, if RP says that I may be this suspended promoters are entitled to run the company, I'm happiest person, my lord.
No. He is not going to make that statement.
If you are
we are not concerned about you running the company. We are only concerned about you defending yourself in respect of the arbitration clause.
My lord, our office is seized. All the accounts are taken over. Nothing is with us, sir. My lord. Everything is office is seized. All accounts are seized. All accounts are taken over. Accounting system is taken over. I'm not having anything. Everything is with COC, headed by the RP. They have to hand over it over, my lords, to run the company. It contains account book, everything contains. single account book. Where I have to run the company?
No such
I'm out of
contention
the
in the
streets
objections
now.
filed by them today, my lords. No such contention in the objections filed by them.
Yes, I have stated, my lords. Entire
He
taken over by the
can
company.
clarify.
Yes.
You can clarify.
Absolutely cease to exist as any authority in the company upon the resolution plan being approved. I have no role to play. I do not have any specific records with me at this point.
You are part of the COC.
Yes,
You are part of the, in fact, you are the chairman of the COC. Therefore, you should know whether the statement that is now being made, that all the books of accounts, the entire thing is now vested with the COC. They have nothing to do. The directors of the company are unable to do anything. If that fact is clarified, I will pass order.
I can make a clear submission, even if such records are available with us, is with only with respect to Arun Aravind.
No, he is saying the entire company. Because there are only one book of account.
I'm not aware of that specific other melons, but I can clearly state that.
Regarding that, my lords, regarding other projects, COC only mentioned, my lord. I keep it separate. I will take your lordship to annexure G only may be seen, my lord. He only says other projects I will not touch, keep in abeyance now. Annexure G, page 84, my lord.
Annexure G is
He cannot say so now. Annexure G, my lord, page 84, clause 10. Application filed by the Messrs. Puravankara Limited in the matter of 2 COCs. The resolution proposal stated that an application has been filed by Messrs. Puravankara Limited and Messrs. Canstable Ventures, the financial creditors of the Arun Parkwood, before the Honorable NCLT, Bengaluru, in the matter of their claim being kept in abeyance. It was also stated that matter now pending before the Honorable Tribunal, and the Kotak Mahindra Bank was also included as a respondent to the said application. Entire thing is taken over. Now only the Arovilla he taken up. Entire file, documents, everything they have taken. Even that Kotak Bank put me out of the office.
That was already adjudicated, my lords. This meeting.
Yes, where are the books of account? They have to give back to me. When they will give back, once that new entity, special purpose vehicle, only segregate this project, then I am entitled to continue as a director of the company, managing director of the company. That's the problem for me. I am out of power from 31-2000. From where I have to bring all the accounts? Nothing is there.
I will pass an order. You please clarify. You take instructions and clarify.
Yes,
Perfect.
if the matter will be passed out, I can clarify within the next 15 minutes. I'll seek instructions from the RP. Instead of keeping it pending for subsequent date, I can seek instructions.
Please get the clarification. Yes. Yes. ಅದೊಂದು ರಿಟ್ ಪಿಟಿಷನ್ ಬಟ್ one ರಿಟ್ ಪಿಟಿಷನ್ ವಿ ಸೆಗ್ರಿಗೇಟೆಡ್ ಅಲ್ವಾ? ಹಾ. ಹುಣಸೂರು. ಹಾ. ಹಾಸನ. No, why you are not able to remove the unauthorized occupation?
In so far as the Unsur is concerned, my lord.
So first one is Unsur, da?
Unsur.
In
Unsur cases, they have already approached this honorable court and application, their writ petition is also dismissed and approached the JT. And their appeal was also dismissed by the unauthorized occupants. So there is no.
ಹೇಳ್ತದಲ್ಲ ಎರಡು ವಾರದಲ್ಲಿ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತದಲ್ಲ ಉಣ್ಸೋದು ಏನು ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ.
Entitlement is 10 acres, my lord. The entitlement is 10 acres. And they are offering 1 acre now.
ಹೌದು, ಇಲ್ಲಿ ಜಾಗ ಇಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ತಾರೆ?
2 acres
ಎಲ್ಲ unauthorizedly occupied, my lord.
ಅಲ್ಲ, ಇಲ್ಲಿ ಪ್ಯಾರಾ 9 ನಲ್ಲಿ ಅವರೇ ಹೇಳ್ತಾರೆ ಯಾವ taken 4 acre 29 guntas.
It is all subject to availability of land.
Lord, one submission, land was reserved and the land has been unauthorizedly occupied and they are in the process of evicting them. Let them evict and give the entitled land at least. Ali nanu request illa ide.
That entitlement also is subject to availability of land, sir. It doesn't mean 10 acres of land have to be allotted to you. Angilla.
Allah, notification itself, the land were reserved under a notification where it was specifically said 10 acres will be granted to each of the servicemen. That was the notification. That's the government order of 1964. And accordingly, all this while that was been happening. It's only for the first time they are saying it's only 1 acre they are going to.
In other cases, my lord, 2 acres is already granted.
Those uncultivated land has been developed. Now, what are the possible where we can account and petitions we are giving to prayer. There are other people who are not from before this matter. So we
Authorized occupants are enjoying 10 acres for me.
All over the other applicants is not true.
Land we are waiting for cultivated land as notified. You know, cultivate money out. At least all the land is cultivated. What the land will get over. Well, they have taken an order.
ಇಲ್ಲ ನನ್ಗೆ 33. 33 ಇದು ಲ್ಯಾಂಡ್ ಲೂಸರ್ಸ್ ಅಲ್ಲ, ನಮ್ದು ರಿಹ್ಯಾಬಿಲಿಟೆಡ್ ಲ್ಯಾಂಡ್ ಅದು. ಇಟ್ಸ್ ನಾಟ್
ಅದು ಇವ್ರದಲ್ಲ. I remember I said it hardly makes any difference whether he is seeking as unauthorized occupant or by filing an application for grant. But when you admit the fact that he is in possession of the land, grant it anta ನಾನು ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ.
ಅವರು ಅನ್ಆಥರೈಸ್ಡ್ ಆಕ್ಯುಪೆಂಟ್ 20-25 acres ಇಟ್ಕೊಂಡಿದ್ದಾರೆ. ದೇ ಆರ್ ನಾಟ್ ಎಂಟೈಟಲ್ ಫಾರ್.
Regarding settlement of service. That never the one line and you submit to the later on, also the point has created instead of block development officer. That when meetings has since then been abolished. Meeting to settle this service. That committee has been abolished. It's almost over now and also the committee now rests with the division of minister. Is noticed that during the actual demarcation of demarcation of the people with private access of land apart for the extent of each 2 acres and was until for cultivation, there
decided that the number of settled in the following created. So far, three ex-servicemen have been admitted to the colony. It is reported that some of the settlers are actually residing in the colony, and their cases for elimination of otherwise we have to be considered. The revenue audit is also very to the colony and all. So third example, not in the process so far, we have prepared three statements. Not my submission. The land available is 3,500 acres. Out of which not 864 acres of land was found unfit for cultivation. Subsequently, not 283 excavation was and 280 excavation have already been settled. From their settled because one back done. Out of that, you have them did not utilize the office. Therefore, the inquiry was contacted, and that was not re-allotted. My service is not because the amount of document was this 864%. Therefore,
but you cannot file application in respect of a land reserved for some other purpose. Baradilla.
Read by the committee, not by the government.
ಆತರ ರಿಸರ್ವ್ ಮಾಡಿಲ್ಲ.
ಕ್ಲಾಸಿಫೈ ಮಾಡಿ ಬಿಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ ಅದನ್ನ ಎಕ್ಸ್ಕ್ಲೂಡ್ ಮಾಡಲಿಲ್ಲ. That land has not been excluded. Let me Lord, there are other government lands available in the same region. I have also filed the RTC.
This land we are giving all effort to accommodate.
The decision of the committee will not be.
This is the I already put that in there. According to the notification of
1952 alla, they are claiming in terms of the provisions contained in the Land Revenue Act and the Land Grant Rules. Correct.
This particular land long back was reserved for not for the entering. Not for
Therefore, 1952 ಅಂತಂದ್ರೆ it was much prior to the commencement of this act. So that cannot be read as a notification passed under this act.
Land was reserved under the notification. My right is under that notification itself.
How?
Below that note, the land, entire land, 3,500 acres of land has been reserved and it is kept intact.
Yavaga?
1952.
You can't claim rights in, under that notification. You are claiming rights only under this act.
Entire village.
Subsequently, there has to be a notification consequent to the provisions of this act.
There is no other notification.
So therefore, you cannot claim that the reservation has already been made and therefore you have to be granted. Ang madak baradilla.
Not entire village.
Sir, in respect of all other districts, you are also aware, you have passed, we've accepted the government order that in case where lands are not available, you will only be granted sites. ಏನು ಮಾಡಕ್ಕಾಗುತ್ತೆ ಏನು ಮಾಡಕ್ಕಾಗೋದಿಲ್ಲ.
After the 21 rule, legal right, 4 weeks, same order has been passed. Only thing will not cause an establishment and one for establishment. We are trying to accommodate giving 1 acre of land. In actual manner, this particular land they can't even take because it's already given. Whoever was there applicant.
Yes.
Case is this not land, yet they admit everything, Lord, land is reserved, they admit that land is reserved. It is meant to be granted for ex-servicemen. Their only cases it has been unauthorized occupied, not the otherwise. In the statement of objection, they clearly say, yes, but unfortunately that has been unauthorizedly occupied. And this court has already directed them to evict them and then grant the land to the ex-servicemen. And now they come up with the offer of one acre, my lord. Where the unauthorized occupants are occupying 10 acres each, which is reserved for the ex-servicemen.
You put yourself into the shoes of these people who have been in unauthorized occupation for the past 25-30 years.
Look, there are some number of other land as
They have also filed application.
As the government advocate said, there are
seeking regularization.
As the government advocate said, there are number of vacant lands available which has not been just occupied by them. It is not at all developed. The entire village is more than 70% of the village is meant for the ex-servicemen only. And they are just sitting over the position of the property doing nothing.
But in other cases, already the 2 acres of land is already granted. And there is an availability of land.
Availability idre kodtare. Is 10 acres. If it is available, they will give. If it is not available, what can they do?
The land was available, they will give the land.
But they can grant some more land. All that I cannot, as a matter of right, I cannot say that 10 acres has to be granted. Yes, though the notification is there. But at least some reasonable land.
Order kodi nan previous order pass madiddu.
11/8.
Copy ilva nimma hatra?
Among the lands, even ready to accommodate.
Then some reasonable offer may not cause. Let them wash their hands saying that 1 acre put because I've been fighting before this court since past 20. I even have petitioner number 2 is fighting for the land since 1980.
Learned AGA submits on instructions that in respect of Unsur.
Seven, 8, 2022, you are.
Unsur Taluka district. Unsur Taluk is concerned.
Mysore district.
Mysore district is concerned. Efforts have been made to evict the unauthorized occupants who have been occupying the lands that were reserved for allotment to ex-servicemen. So, however, it is stated that the district administration has decided to at least allot at least 1 acre each to the petitioners herein. And if there is any availability of land, preference will be given to the petitioners for allotment of more than 1 acre of land. So, Learned AGA submits that the matter may be taken up during the first week of February. So, next para. Accordingly, release this matter on 6th of February, 2023.
My melody, serial number, point number.
ಹಾಸನ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ನೀವು ಹೇಳ್ತಾ ಇರೋದು ಆಗಲ್ಲ ಅಂತನಾ? The learned AGA is also required to secure instructions in respect of the other petitions pertaining to Hassan district. Yes. If you are deciding the case, then we will record it. Yes. Previous matter.
I have the response for 1 minute.
Yes.
And for the petition.
Ah.
I thought instruction from my client, it is very clear that I do not have in my possession any books of accounts or any transactional details so far as the company is concerned on this date or on the date of do not have anything from the date of the resolution plan being approved. Since then, I do not have in my possession any document.
So the directors of the company have been running the company.
So far as that I was concerned about Arun, the resolution applicant has taken over whatever documents in relation to that project, but not in so far as any other project. So means like whatever clarification I sought from my client, it is very clear that I do not have currently in my position anything to do with the books of accounts or any accounting related documents that are pertaining to the company.
Then who has got it then?
The resolution applicant, Golden Hatcheries, has got it upon approval of the resolution plan by God. And even they have only with respect to project Auroville, not in relation to any other project. Is what is that was intimated to me.
Mr. Bhagwat.
We are having a single accounting system, my lord.
Your clients will have to file an affidavit stating that they have not been running the business of the company.
Yes,
pursuant to the orders passed by the NCLT.
Yes, madam. Yes, madam. From 31/1/2000, I am not doing anything, my lord. 31/1/2000, when admitted. Yes, madam.
It is the contention of the first respondent that consequent to the orders passed by the NCLT, on 19th of March 2021, the directors
January 2020. 31st January 2020, my lord.
No, I'll come to that all.
Yes, ma'am.
The directors of the first respondent company are not permitted to run the company. So, in fact, it is submitted that by an earlier order dated 31st of January 2020, the directors of the company were kept under suspension, and therefore they have not been exercising their rights as the directors of the company right from 31st of January 2020. So that being the position, it is submitted that if the first respondent company through its directors are directed to appear before the arbitrator for arbitration, they will not be in any position. They will not be in a position to secure any records and defend themselves before the arbitrator. Full stop. Next para. On the other hand, a statement is made on behalf of respondent number 2, who is represented by the, which is the company represented by the resolution professional. For the resolution professional.
No longer upon approval of the resolution plan. So I will be called only as erstwhile. I do not hold that position and I cannot represent them. I'm only representing CPI in a personal capacity. For the erstwhile.
Or it's all right. Resolution professional.
On the other hand, the submission is made on behalf of R2, which is a company represented by resolution professional.
Professional. That consequent to the orders passed by the NCLT, on 4th of November 2022, approving the resolution plan dated 21/7/2021, along with the scheme of demerger submitted by the applicants before the NCLT. And appointment of the COC. What do you mean? What is the full form of COC?
Committee of Creditors.
Committee of
Committee of
Creditors.
Creditors.
Yes, Mirror.
Committee of Creditors. The resolution professional lost all the rights that were attached to the said post. So, however, the resolution professional continues to be a part of the COC as its chairman. Stop. On instructions, the learned counsel for the erstwhile resolution professional submits that the COC is not in possession of the books of accounts of the company, and it is not the COC which is running the affairs of the company. Full stop.
But the COC would stand dissolved.
There is no longer a we party that rejected the resolution of the council whose favor the resolution plan has been approved. So the COC also doesn't no longer exist since the resolution plan.
Then what is it? What is the plan then? Resolution plan.
To give this project
According
to
to which,
applicant ballot.
Annexure G, your committee of creditors
this was dated 22 February 2021. As of that date, COC was still existing. But this approval only happened in 4th November 2022, which is subsequent to Annexure G. Since 4th November 2022, COC doesn't exist because the resolution plan has been approved. And like I just submitted, insofar as the books of accounts pertaining to this project has been handed over, the resolution applicant. In this case, Golden Hatchery, represented by Mr. S.M. Karan Pasha.
Previous sentence.
On instructions, Lord Counsel for erstwhile resolution professional submits that the COC is not in possession of the.
Allah. Even the COC is not in existence subsequent to the resolution plan approved by the NCLT. Full stop. On the other hand, in terms of the resolution plan, the applicant creditor which is a consortium of two proprietary concerns.
This is a resolution applicant, my lord. They are creditor is Kotak Mahindra. They are resolution applicants. RA.
Successful resolution.
Yes, well, RA. They are called RA, my lord. Creditor is Kotak Mahindra Bank, who have approached the NCLT. Yes, ma'am. According to the RP now, he has handed over all the books to the RA.
Resolution applicant.
Resolution applicant. And there's a direction of the NCLT at page 80 will be kindly seen, my lord. Your lordship is page 80, which shows two things. Resolution professional or holding the accounts, the resolution professional shall forward all records relating to the conduct of the corporate insolvency resolution process and the resolution plan to the board. Now, board is replaced by COC. In the place of COC, RA. Now, earlier COC was there. Earlier, original promoters are suspended. COC is taken over. After 4/11/2022, in the place of COC, RA will come. They will constitute a board. Then they have to make a special purpose vehicle to demerge the Arovilla project. So they have to hand it over to board consisting of RA.
On the other hand, in terms of the resolution plan, the applicant creditor, which is consortium of two proprietary
resolution plan, the resolution professional was directed to forward all records relating to the conduct of the corporate insolvency resolution process and the resolution plan to the board. Stop. The board, which was taken over by the COC.
RA. Earlier COC. Now after 4/11.
Now vests with the resolution applicant.
Applicant. Yes, madam. Yes, madam.
Applicant. Stop. Next para. That being the position, comma, it would be difficult for this court to direct the respondents, be it the first respondent independently or along with the second respondent, to go before the arbitrator, since it's clear that the directors of the first respondent company are not in a position to have access to the records of the company. Stop. Next para. That being the position, comma, this court is of the considered opinion that the matter requires to be adjourned until the process of demerger is completed and the first respondent company and its directors are in a position to appear before the arbitrator.
My humble one submission. Yes. The arbitrator may be appointed and I may be permitted to file the claim statement. Meanwhile, our books na your lordship may kindly. And that is only in respect of this particular project, my lords. It is only in respect of this particular project.
No, sir.
Your lordship may kindly appreciate.
The learned counsels are permitted to
move
a memo for posting consequent to the demerger. That would be demerger that would take place consequent to the directions issued by the NCLT.
Yes. No, the NCLT wouldn't issue further directions for me.
Demerger. In terms of the resolution plan.
That is where the NCLT
is the resolution plan.
NCLT is functus officio so far as this case is concerned.
No. The resolution plan is required to be executed, isn't it?
How Swami? That is in so far as a particular project.
Correct.
But so far as the others could be delineated and they may be.
That is not for me to direct.
Your lordship may kindly appreciate if that is the case. None of the other projects.
Sir, the directors are not in a position to have access to the records.
That is a very
what can we do
that they are taking. Your lordship may kindly appreciate.
No.
Your lordship may kindly appreciate. Somehow or the other, they would want the arbitration not to proceed. My humble submission, this has nothing to do with the books.
If they don't have access to the records, what will they do?
The point is, I have all the records to show that the JDA was entered into. They have the access.
No, sir.
That particular project is what the records confined to, Milords. Illi, so far as the respondent number 2 is concerned, it confines only to that particular project,
I have passed the order. It's all right. All the other matters that have not reached will be taken up next week.
Okay.